Yes, good morning.
My notes.
Yes.
If I may mention, part 2, my notes, item 31 onwards
31 onward.
to 47, my notes.
31 to 47, what are these items?
My notes, these are connected matters. It is relating to my notes compensation amount of my notes land
Okay.
acquisition. It's a question of law there, my notes. The NH, IDCL, my notes, they're asking for praying for time, my notes.
Acha, okay. The respondent side.
Yes.
Item, what you said?
31 to
31
46.
to 47.
46.
Acha, 31 to 47.
Your Lordship, if you permit, if the item may be fixed on 10th August, because the main counsel has to come from Gauhati.
Okay. Who's appearing?
Mrs. Joydi Saikia,
Joydeep Saikia.
he will be appearing.
Okay. Mr. You are for petitioner, right?
For the respondent,
Yes, no,
Manoj
you are for the Mr. Jordan Romingtonga, learned counsel appears for the petitioner, and Mr.
Banal Huma.
and be learned counsel for the respondents. You are appearing for all the respondents.
Yes, Your Lordship.
Respondents. A prayer is made on behalf of the learned counsel for the respondents that the matter be taken up on 10th of August.
Yes, Your Lordship.
10th of August. Prayer is allowed. List this matter accordingly.
Much obliged.
Yes.
Lord, item 2, part 2 of hearing list as agreed by the both parties if this matter be taken up on 6th of August.
Otherwise, it is fixed for tomorrow. It is fixed for 21st of July. Right. So why not tomorrow? Okay. You make the prayer tomorrow
Okay.
or what?
Yes, ma'am.
Okay. As prayed for by the learned counsel appearing for the respondent. You are for respondent.
Yeah.
Respondent, list this matter. When do you want?
6th of August.
Oh, list this matter on 6th of August as prayed for.
Much obliged.
Okay.
Daily list for admission, item number 1.
My lord, this is a regular second appeal, and I'm appearing for the appellants as a legal aid counsel.
Today it has come up for the first time.
First time, in fact, my lord, on the last occasion, the condonation of delay was condoned, and today is listed for admission, my lord.
Okay.
And along with this appeal, my lord, I had filed one application, which is IA 106 of 2026, but
That
it has
is
not
not
come up
there.
today, yes, my lord.
That is not
That
there.
is for stay of the impugned judgment and order.
Okay.
My lords, because the first appellate court has directed me to demolish my house, my lords.
Acha.
The core issue involved is regarding overlapping of land, my lord. The
Core issue is what?
overlapping of land, my lord.
Overlapping.
Yes, my lord.
There will be two land certificates. There are no two land certificates or what?
They are, in fact, my lord. The respondents number 1 herein had filed a suit before the learned trial court for extension of her LSC, my lord.
Okay.
That is our main prayer, extension of LSC,
Extension of our LSC.
my lord. But if her LSC is extended, then it will be overlapped with my land. I have a village council pass, my lord,
Okay.
which was issued in the year 1974. Her LSC was issued in 1986, my lord.
Okay.
And I had constructed a house in the land, the disputed land.
Where
And
she says that it should be extended.
it should be extended, and as per, there are two surveyor reports actually, my lord. One surveyor report says that even if it is extended, then there are no encroachment. It will not be overlapped. But the first, that is the second survey report. But the first survey report says that her LSC should be extended, and my VC pass will not prevail over her LSC.
Acha.
So the learned trial court had dismissed the suit filed by the respondent number 1 herein. And being aggrieved, she had filed an appeal, regular first appeal before the first appellate court, before the
But the
district
trial
judge.
court issued in your favor. Directed, gave its order in your favor.
In my favor, in a sense, I do not have any counterclaim, but the suit filed by the respondent number 1 herein was dismissed.
Acha.
Means yes, in my favor, in a sense. And being aggrieved, she had filed a regular first appeal before the Lane district judge. But the Lane district judge had decreed in her favor,
Acha.
and
Saying that the LSC, there is overlapping.
overlapping, and her LSC should be extended and correction should be made in our LSC, and my building which I have constructed in the Sudan should be dismantled.
Demolished.
Yes,
Acha.
demolished, my lord.
Now you have come against that.
My lord. And they have, in the meantime, they had filed an execution case before the executing court, my lord. That I have prayed for stay in the IA, my lord.
But the application is not there before me.
Yes, my lord. But
No order can be passed as to your prayer of interim relief, but
I had filed, my lord, along with this appeal, my lord.
But it's not listed. Whether you have made prayer here also for stay. I don't think so, right?
In the main prayer, I have not made prayer for stay, my lord.
Yeah,
But
here
I
you have not-
since I have filed a separate application, my lord.
Yes, but then the application is not before me today.
Yes, my lord. If
So
it-
let me issue notice today here,
yes, my lord.
and when your application will be listed, you pray for stay then.
My lords, at least if status quo may be maintained, my lord, because
But without the prayer before me, how can I order that?
then, my lords, if it may be taken up as a last order, then if the application may be put up today, my lords,
Okay,
because
try to bring the application.
it's with the registry, my lord,
Okay, you try, you bring it, you give me give a requisition to them and bring it.
my lord.
Okay.
If your lords may direct, my lord, the registry to put up today, my lord.
It's okay, you give the requisition, they will allow and then they will put it up.
My lord, my lord.
Okay, after some time then.
Item number 2.
Yes, item 2.
My lord, this contempt petition is pending for about 6 years.
19.
2000,
On the earlier occasion, you were not there.
I was there, my lord.
No, on 23/4/2026 in the month of April, you were not there, and then
On
of
that
course
particular
you took,
day, my lord,
Huh.
the land's AG took leave. That is why I was not there. Because
matter is ready for hearing. Okay, can it be done today?
yes, my lord.
Yes,
Your
Miss
Lordship,
Mary.
if the matter can be taken up tomorrow, I'm a little bit handicapped. I don't have the file with me.
Acha.
In fact, this matter was briefly heard by Your Lordship sometime, I think, last year, end of last year. Only
By me?
there's only, yes. There's only one portion that we have to cover. It's a small matter.
Now, acha. What is the violation?
The violation is, my lord,
Only one aspect you said to be
Yes,
considered what?
there are two tires that we have to comply, A and B. But then the second one is admittedly complied with, and the first one is a little bit disputed.
Acha. Acha, so second one is completed, but the first one is,
my lord.
what is this
regarding-
matter?
Regarding clause 5.3, the operative person.
Oh, 5.1 and 3.
Yes,
That
Hamar
Hamar community,
community.
yes.
yes, madam.
I
Okay.
think you have already heard.
So what happened there? I mean, 5.1 was, I think what I remember is the Hamar language should be fixed
Used
as
as
the
primary
medium of
language.
instruction.
Yes, yes.
Yes,
At the
madam.
primary level.
Yes,
Yes.
correct.
But then you said that it is limited to a particular area, so need basis it has to be done.
Yes. Plus,
my lord.
yes, that we have to go into. But we have already issued the Mar language textbook, which they have declined to use. So
Acha.
that, we have to go into that's in that detail
Okay, so tomorrow.
tomorrow. Yes.
Tomorrow, my lord, I'm having two case hearing in court, number 1.
Okay. So then you fix on a date, except Friday.
Thursday. Thursday.
Or if Miss Mary is ready, I can hear it today only.
Yes, yes, yes. If the matter can be passed over for the time being.
Okay. After some time,
Okay.
let her look into. After some time, huh?
Item number 3 and 4.
Yes, Mr. Medhi.
My lord, may it please your lordship, this contempt case is
Huh.
passed again.
Learned counsel for respondent was granted time to file counter affidavit. What happened, Mr. Medhi?
And the writ petition, my lord, there is the
This is what? This is contempt case?
Actually, we filed affidavit, my lord. It is in the affidavit also, my file.
You had filed? No.
There, my lord, there is one is contempt and another is my repetition. Repetition is filed by us, my lord. In that case, my lord, the court some viewers they may be liberty to file affidavit, my opinion opposition.
In the writ proceeding?
Probably it was reflected in the contempt order.
Acha.
Both are linked, my lord.
Acha, writ, in the writ, what happened?
Read we file, my lord. Railway file, my lord.
In the writ, there is no prayer for filing affidavit in opposition.
Maybe I am wrong. Probably it was repeated.
Then this matter has been disposed of, but I don't know.
My lord, it was my lord disposed of, my lord. Subsequently, actually there is a order in contempt as well, my lord, in said repression, my lord, to file a review petition against the order which they in contempt petition, my lord. We have filed a review petition, my lord, before the concerned judge. It was, my lord, dismissed on, and there is some observation also, my lord. And if we agree with this verification report as well as assessment report or all these things, we can approach the appropriate court, my lord. So thereafter we
So review application you have filed and it is dismissed.
dismissed. But then thereafter again we filed another review petition in WPC 1 on 2 of 2024 like this, my lord.
Review application in this writ.
Yes, my lord.
This writ has been disposed of.
My lord, there is two review petition. Another is, my lord, in contempt, which the order was contempt. That was dismissed, my lord, with some observation. Thereafter, we approached this honorable court, my lord, by filing another review petition in WPC 1 and 2. My lord. And, according to that petition, honorable judge, my lord, allowed our review petition and revived the petition WPC 1 and 2, my lord. And tag with the, because the matter related same issue, my lord. So it was tag with, my lord. So on last occasion, my lord, is court directed court on the observation was that they may file a affidavit in against the WPC 1 and 2, my lord. But probably it was, my lord, wrongly, my lord,
Not recorded.
wrongly reflected in contempt petition, my lord. That may be.
Oh, acha. In the contempt it is written that respondents were supposed to file.
Yes.
So it should have been in the writ, you said.
Yes, yes.
So in the contempt application, you will not file any affidavit, Mr. Medhi?
We file an additional affidavit also, my
Oh,
lord.
you had filed.
Yes.
So, okay, whether you will file your objection in written writ petition?
No, my lord, if I may be allowed to make verbal submissions, my lord.
Acha, today?
Uh,
Respondents are, how many respondents are there? In the contempt I am talking of?
Contempt, my lord, we are mainly the railway is the main respondent, my lord. So, my lord, in this case, my lord, this would file our affidavit, my lord. The assessment was made by the state government, Mizoram, my lord. Accordingly, assessment was sent, my lord. Thereafter, the contempt petition was
Acha,
filed.
no, in the contempt application, there are so many respondents, 6.
Yes, my lord. The 5 and 6, 6 has been the new incumbent, my lord.
Yes, madam.
So,
6 is the new incumbent.
yes,
Oh, this is railway, my lord.
Acha, Mr. Medhi is appearing.
Yes, ma'am.
yes, my lord.
5 also you are appearing.
Yes, well, same, my lord.
1, 5, and 6 are the same post, my lord.
Acha.
So they have been newly.
What about 2, 3 and 4?
My two is railway, my lord. One is state government.
2, 5, and 6 are the same, my lord. 1 and 3 have already filed. However, 3, there was a new incumbent, so there was replaced by number 4. So it's like a 1, 4, and 6.
Okay.
So 1 and 4 have already filed their affidavit, and the number 6 have also filed their affidavit, my lord.
Acha. So appearance, who is appearing for 1, 3 and 4? Venisham, you are appearing? No.
Mali.
Who is the instructing counsel here?
State government, district collector.
No, he is Dinesh Kumar.
Dinesh Kumar, I am.
Oh, yeah. John L.T. Sangha, district collector.
Your Lordship, for item number 1, Ms. Lanmal Swami is appearing in contempt case.
Acha. For respond number 1.
1 and 4, my lord.
And 4? 4 also.
Yes, my lord.
So where is she? Or I call up after some time? Let her come.
Basically, district collector is government of Mizoram, my lord. They sent assessment, my lord, to railway, my lord. So they are part almost complete, my lord.
No, this is contempt application. Department will not get involved.
No, my lord.
This is Zone LT Sangha. These are all personal.
Yes.
So we will wait for some time. Let the council come.
Yes, Your Lordship.
Okay. This is also after some time. Whenever she comes, I'm here. Acha, okay. After you come back.
Item number 5.
All after some time. Item number 5. Yes.
Your Lordship, I'm supposed to file affidavit on behalf of the latest implement, that is the
16.
CE, yes. So, Your Lordship, I'll be filing my affidavit within a week time.
You had taken a
Yes,
time
yes,
for
I have received the instructions, Your Lordship.
Acha.
I have received the instructions. Positively, I will file in a week.
Okay. Heard, Miss? Petitioner counsel? Your name?
Valentina Dinpui, my lord.
Okay. So and so for the petitioner and Miss Mariel Kyangte, learned counsel for respondent number. Respondents, you are only for 16 or others as well?
16, Your Lordship.
Respondent number 16. Miss Mariel Kyangte, learned counsel, prays for a week's time to file the affidavit in opposition. It is seen that she had taken time on earlier occasions too. As such, the prayer is allowed, but with the rider that she has to file her affidavit on the next date fixed without any fail. List this matter again on when? You need 1 week's time.
Yep, 1
List this matter on 30th of July?
My
Or
lord,
okay,
if it may
let
be-
this fix it on 4th of August or 5th of August?
5th of August, my lord.
5th of August will do, Mary?
Yes, Your Lordship.
List this matter on 5th of August.
Deeply obliged.
Item number 6.
My lord, in this matter, on the last occasion, Mr. Gupta has submitted that he will be
So,
Submitting-
Mr. Gupta, what happened? You were supposed to submit your wakalat number.
Waiting for some time, my lord, to file affidavit, my lord, and also, my lord, similar matters, my lord, they are pending before the principal seat, my lord, for hearing, my lord. Similar writ appeals, my lord, on the issue, my lord, whether payment under both the sections, that is section 28 and 34, can be granted or not. Lot of petitions are pending, my lord, for hearing on 12/8. So, my lord, I am praying for some time to file affidavit, my lord.
Have you filed your wakalat number for respondent number 8, 9 and 10?
My lord,
It is reflected in the office note.
it's not yet submitted, my lord.
Your Lordship, the London Council cannot make a submission without the wakalat number, Your Lordship.
Yes, this is what,
Expecting to appear, my lord, I will file it, my lord, shortly.
And Your Lordship, further, this contempt case has been pending since 2024. And the council cannot hide behind a similar matter. This is a contempt matter, Your Lordship. And the writ appeal has also been, the condemnation of delay in this writ petition, this writ appeal was more than 600 days, which has not been granted, Your Lordship. So,
Acha, writ appeal against this order.
yes, and
There is a condonation of many days
many days.
and it has not been condoned.
No.
Application is pending.
Not pending, we're just waiting for the order.
It was heard. The condonation application was heard.
By
Heard,
the
my lord,
division
and
bench.
already resolved.
It was heard by the division bench.
Yes, yes, my lord.
The order was not issued.
Order is reserved. Order is reserved, my lord.
Order is
In the
reserved.
IA, the condonation only. Yes.
Okay, you file your wakalat number and then
Hello.
only
Well.
I can hear your submissions, okay? But then last order, it reflects that you had already taken time to file.
My lord, I will file it, my lord, because I have to come physically, my lord, there.
Okay. Mr. H,
Unless some strict order be passed for 2 years, Your Lordship, it's still pending.
that is there. Appeal is also filed, of course, it is yet to be condoned. Okay, right, Mr. H. Gupta heard Mr.
Jonathan Nelson.
Jonathan L. Silo.
Yes, Your Lordship.
Learned counsel for the petitioner. Mr. H. Gupta, learned counsel, submits that he is yet to file his wakalatnama to represent respondent number 8, 9 and 10, and that he will be filing it soon, and that also in the meantime he will file the affidavit in opposition in the instant case. He further submits that appeal against a writ appeal against the order, comma, the violation of which has been challenged in the instant, the violation of which has been raised in the instant contempt application has been filed, accompanied with an application for condonation of delay. However, the learned counsel submits that the delay is yet to be condoned and the application is yet to be condoned, full stop.
Your Lordship, we can produce the order as soon as it comes out. So in this matter.
It is as such directed that the learned counsel will produce the order passed in a delay condonation application mentioned herein above as and when it is delivered. Mr. Gupta is also given the liberty to file his wakalatnama. However, time was earlier taken to file the same, but it was not filed. As such, Mr. Gupta, if he represents 8, 9 and 10, should file his wakalatnama by the next date, failing which the court will proceed with the instant contempt case. List this matter on which date? 7th of August? 7th of August 2026.
Your Lordship.
Item number 7.
Okay, Mr. Yes. Respondent number 1 and 2 have not represented. Respondent number 3. Yes, you are for?
And for respondent number 3.
3. Miss Mary, you are for 1 and 2.
Your Lordship,
Service is complete.
Yes, my lord.
When was the service
yes, Your Lordship,
complete?
I represent respondent number 1 and 2.
You'll appear.
Yes. Over and fight down there.
AD card has returned back on so and so, February. No one appears. Oh, last time there was no representation on behalf of 1 and 2. And the court may consider passing appropriate order. You are appearing for 1 and 2?
Yes,
No?
1 and 2.
Okay. Otherwise, it has become a practice, it seems, that respondents receive the notices but they do not appear. In such cases, warrant has to be issued. But then you are appearing, it's okay. So you will file affidavits.
Yes, Your Lordship.
3 has filed affidavit.
No, my lord. I'm praying for time for
This
filing.
is contempt, right? So you something is there. What is this? No, the contempt petition only. Okay. No affidavits here. Okay, you file your affidavits by the next day. Heard Miss. Yes.
Valentina Pui.
Okay. Valentina Landin Pui. Heard Miss Valentina Learned Counsel for the petitioners and Mr.
Elias Ramsona.
Sona, Learned Counsel for respondent number 3 and Mary L. Kiante for respondent number 1 and 2. The respondents are all the respondents are represented. Full stop. Prayers are made on behalf of them to grant them some time to file their affidavits. Prayer is allowed. All the respondents are directed to file their affidavits by the next date fixed. List this matter on
5 August, my lord.
5th of August.
Much obliged.
Item number 8.
8. Yes.
Here also, my lord, no.
Contempt only.
Yes.
Yes.
My lord, similar issue, my lord. Here, my lord, I have received wakalatnama and affidavit, my lord, both I will file it together, my lord, because the affidavit is ready, my lord, with me, my lord.
For 7 and
Hereby I
8.
have to do for a week's time only, my lord.
You are representing which respondents?
My lord, 3, 4, 5, 7 and 8.
Okay. 3, 4, 5 you have filed your wakalatnama, but 7 and 8 you have not. Right?
I have, yes, my lord, yes, my lord.
Okay, heard Mr. C.
H. Jodin Sama, my lord.
H. Your name is there? Yes, H. Zoding Sangha, Learned Counsel for the Petitioners. And Mr. H. Gupta, Learned Counsel for Respondent number 3, 4 and 5. Mr. H. Gupta submits that he is representing respondent number 7 and 8 as well, and that he will file his wakalatnama within a day or two. He also submits that he will be filing the affidavit also on behalf of the said respondents. Prayers are allowed. The Learned Counsel should file the wakalatnama as well as affidavit on the next date fixed. List this matter for further consideration on 7th of August.
My lord, yes, my lord.
7th of August.
Obliged.
Item number 9.
May it please your lordship, appearing for the petitioners, my lord, this is a civil revision, Lok Adalat award matter. And my lord, we have received the affidavit and thus all the pleadings have been completed.
What about respondents? Nobody appears?
My lord, I believe that my learned friend Mrs. Emily L. Sangte had been recently given birth, so she cannot attend today.
Achha, achha. She is on maternity leave.
Yes.
The counsel appearing for 1 and 2.
Yes, your lordship.
This is against the Lok Adalat order.
Yes, my lord.
Lok Adalat orders will be in pursuance to some agreement. So you must have agreed to certain conditions before the Adalat.
But my lord, this Lok Adalat award has been given without my consent. So.
Achha. Otherwise, Lok Adalat only will be order will be entered only on agreement. You did not agree to the.
No, your lordship, we did not agree. I did not agree to.
Where is that Lok Adalat order? Just show me.
My lord,
last
it's
page.
on page number
23.
20, my lord.
20 or 23?
20.
Achha, this is handwritten.
Yes.
No,
and
here you see on page number 24, in the year 2024, dispute arose between the parties regarding the landed property gifted, and the Lok Adalat made an agreement settlement as under. You are not there. You are not present.
My lord, I'm present, but it was given without my consent. So, and also your lordship, respondent number 2 was reflected on the Lok Adalat award, but she was not present during this.
And you see the first paragraph, dispute between the parties having been referred, and the parties having compromised, settled the case matter, the following award is passed. So it seems it is a compromise between both the parties. Again, now challenging the same actually does not arise. Okay. Respondent sides are not there. We will examine on the next day. Learned Miss
Valnal Santami.
Miss Valnal Chandami,
Yes, sir.
Learned Counsel for the heard Miss so-and-so for the petitioners. For the petitioner, it is stated by the Learned Counsel for the petitioner that the Learned Counsel appearing for respondent number 1 and 2 is on maternity leave and as such has prayed for some time. Prayer is allowed. List this matter after 2 weeks on a date to be fixed by the registry.
Much obliged.
Item number 10.
This is also a CRP, yes.
May it please your lordship, in this matter, counsel for respondent number 6 is to file the counter.
It is seen in the office note. Respondent number 6 is yet to file response. You are for?
Respondent number 1, my lord.
What?
Respondent number 1.
1.
Yes, my lord.
Respondent number 1 had filed the affidavit.
Yes,
2
my
to
lord.
5, they said they will not filing any affidavit. So 6, who appears for 6?
6 is from Legal Aid Counsel, Miss Emily L.
Oh,
Chante.
she is on maternity leave.
Yes, my
Yes,
lord.
Miss Madam.
Okay. Okay, heard Miss so-and-so, learned counsel for the petitioner and Mr.
MS Muktan Moya for respondent number 1.
for respondent number 1. What about 2 to 5? They have not appeared? 2 to 5 is a government advocate. Miss Mary L. Chiangte appears for respondent number 2 to 5. However, there is no representation on behalf of respondent number 6. And on the earlier occasion, learned counsel appearing for respondent number 6 took time to file the affidavit. However, it has been stated at the bar that the counsel appearing for respondent number 6 is on maternity leave. And as such, this court finds it fit to therefore the matter. Full stop. The registry to list the matter after a period of 2 weeks from today.
Item number 11.
This is contempt.
Your Lordship, I have filed show cause reply affidavit on behalf of respondent number 2.
1
I
and
represent,
2.
yes.
But 3 and 4 they have not filed.
My lord, I'm appearing on behalf of my senior, Mr. Pisil Thangmoya. I pray 3 weeks time to file for the affidavit.
Okay.
I have no objection.
Okay. I heard Miss. I again forgot your name. B. Lalram Nemi, learned counsel for the petitioners, and Miss Mariel Khiangti, learned counsel for respondent number 1 and 2. 1 and 2. And Miss
Lal Omi.
Learned Omi,
Yeah, 3 and
learned
4.
counsel for respondent number 3 and 4. Learned counsel for respondent number 3 and 4 prays that she be allowed some time to file the affidavit in opposition. Prayer is allowed. List this matter after 2 weeks on a date to be fixed by the registry.
Item number 12.
Lordship, I'm appearing on behalf of my senior, who is the special PP. And as per the office note dated 2/6/2026, service of notice upon the sole respondent return unserved with a note insufficient address.
Okay, this is appeal against acquittal.
No, Lordship, this is a criminal petition against the Zimanama order.
Oh, Jimmanama order.
Yes, Lordship.
You have challenged the Jimba given of something to the respondent.
Yes, Lordship.
What is that article? What is given in Jimma to him? Vehicle? Or what?
Yes, my lord, it was a
Vehicle. Vehicle, Supreme Court has said, instead of keeping it in the police station, you should always give in Jimma to the owner.
Yes, Lordship.
Rightly it was given. Why have we challenged that again?
Lordship, we have one grounds that we did not given an opportunity to file any objections in the learned special court file.
Where is the Jimma order?
Starting from page number 20, annex 1.
20.
Yes, Lordship.
A special PP was there. What happened?
Yes, my lord.
2 vehicles, Tata Nexon and Mahindra Scorpio.
Yes.
Despite giving chances, you have not filed your objection. But your counsel was there, present when the order was passed.
Yes, my lord, that is correct.
So, you were given many chances, you did not file objection.
But my lord, it was between the winter vacation and
Whatever it is, the court has written down this, that, see, paragraph 4, no objection is filed by the respondent despite given chances since 5/12/25. And it is, order is dated
29/1/2026.
Are you seriously objecting to this Jimma application, Jimma order?
Yes, Lordship.
But then you were given chances to file objection. You did not. Your counsel was there present. And it's a recent order. They said that the vehicles, if it is kept for long in the police station, will get damaged. And so there are chances of theft also. And of course, there will be confiscation, but after the trial is over. So better to keep it with the owner. So it was given, and in the conditions were given. Jimma bond of 7 lakhs. Right.
Yes, Lordship. But my lord, as per my limited knowledge, we have only received the application for Zima Nama only on 29/1/2026, which
Okay.
is the date
29/1?
the order was passed. Yes, Lordship.
Then I have to see the
Before
orders
that, we have
because
no knowledge.
because the court said that you were given chances since December. Where is the order sheet? What documents have you annexed to show that you got the application only late January? This case is this case deserves dismissal, Mr. Counsel. Shall I pass the order?
My lord, I'm only appearing on behalf of the special PP, so if this matter may be listed tomorrow, maybe.
Okay. As prayed for by the learned counsel appearing for the appellant, list this matter tomorrow.
What's up, Mr.
Item number 13.
Same or what? Jimmanama?
No, my lord, this is bail, granted bail application, order, bail order, Lordship.
Bail order, cancellation of bail.
Yes, Lordship.
The service is not complete.
Yes, my lord, it is not.
Heard learned counsel for the petition for the what petitioner. The office note reflects that the this is the second time. Okay, the office note reflects that the service upon respondent, sole respondent, service
Yes, my
upon
lord.
sole respondent is not complete, as the AD card has not yet returned. Since the notice for service of since the steps for notice of service of since the steps for service of notice is taken recently, this court finds it fit to await for some more time. List this matter again on 6th of August.
What's up, please?
Item number 14 and 15.
State of Mizoram, this is I in criminal appeal.
My lord, on the last occasion, I had submitted that I will file my work. And I had sought time for filing my objection to the condonation of delay, my lord. And accordingly, my lord, I had filed my power last Thursday. So I need further time to file my objection in the IA 14, that is the condonation of delay application. Yes, my lord. It's a 193 days delay.
193 days.
Yes, my lord, I have strong objection.
What is the offense under which?
It's a PC Act, my lord. It's an appeal against acquittal, my lord. I was acquitted.
PC Act.
PC Act, my lord.
Okay, you file your objection then.
My lord, if 2 weeks may
Let it be
granted,
heard on merits. Why objecting to that condonation?
I have a strong objection, my lord.
Right. Everyone has a right to be heard on merit. But anyways, this is appeal against acquittal. He has been declared innocent twice, rather. Okay. Heard Mr.
Seetlan Tianglin.
C. Lalfaghzwala, learned amicus. No.
I'm appearing for the
Special,
Mizoram
yes.
Lokaयुक्त.
Learned special PP for the state of Mizoram.
Mizoram Lokaयुक्त.
Yes, huh? Yeah, Lokayukta, true Mizoram Lokayukta. And Mr.
Seetlan
C.
Tianglin.
Thangliang Lima. C. Lang Tiang Lima, right? Lang.
Lord.
You
Tlan.
start with L.
TL.
TL. So you will pronounce it as what?
Tlan.
Tlan.
Yes.
Tlan. Tian Lima for the sole respondent. Learned counsel for the respondent submits that he has strong objection to the delay condonation, he has strong objection to the condonation of delay in the instant case and submits that he will file an affidavit in opposition. Prayer is allowed. Release this matter on 5th of August. Or it will be early.
Or my lords, if possible, on 11th of August.
Okay, Tuesday.
My lord.
10th of August, Monday.
My lord.
Okay. 10th
Obliged.
of August. It will come for orders only.
My lord.
10th. Yes.
Item number 16.
Yes.
May I please, Your Lordship? Lordship, here, in this case, Lordship, the petitioner was arrested on 2011-2025.
This is
on
for
the basis
bail.
of, Lordship, this is for bail, Lordship.
Okay. Yes.
Yes, Your Lordship, I will represent the NCB, my lord.
Okay.
So if I may kindly be granted 2 weeks' time for filing my objection.
Is it? Oh,
My
this
lord.
is bail. You can do it orally.
No, my lord, I have to file it because I have to obtain instruction from the authority. Otherwise,
Achha.
I...
Okay, Mr. Ahmed, he wants time to file it.
Here in this case, Lordship, that I am raising the issue of violation of constitutional rights. So I am praying for a short date, Lordship, if he is asking for date, Lordship. Because Bihan Kumar says if it is found that constitutional rights are violated, then he has to be released forthwith. And in my case, Lordship, from the rejection order also, it is apparent that there is violation of constitutional rights.
So, Mr. Counsel, see, there is specific direction in Vihan Kumar that...
I'm aware, Lordship. I'm aware.
Okay.
But still, it seems that there is substantial compliance of that order from the Supreme Court.
Okay,
So-
you can show it without filing any affidavit. Because we have to follow Supreme Court directions. So if somebody is detained in violation of Article 21, 22...
I received the instruction only the copy of the petition only recently, my lord. So I have to go through it and I have to obtain instruction from the NCB authorities, my lord. And actually, it was the state government who was impleaded as a respondent, my lord, not the NCB. So NCB was recently impleaded, my lord.
So, okay, when can you... you are not required to file affidavit, you can orally submit. When can you do it?
No, I prefer to, if your lordship permits, file affidavit, my lord.
Okay, agree on a date?
On 3rd of August, my lord.
On 3rd of August?
My lord.
Okay, Mr. Ahmed. Although there are directions, but he is saying...
Can it be this week, Lordship, if possible? Friday, Thursday, any day?
No, my lord. I think I am handicapped.
Because otherwise, it is apparent that, Lordship, that section 36 is violated and as well as
But then,
48 not complied with.
But then we actually, Mr. Counsel, we cannot wait if there are any violation of the constitutional provisions.
Violation is not there, my lord.
There show me 47 notice. Show me.
Page, Lordship, may kindly see page 57. That is the arrest memo.
57. This is memorandum of arrest.
Lordship.
Not signed by any witness.
Not signed by any witness. Now, if your Lordship turns to page 60, this is the intimation of arrest. Intimation of arrest and grounds of arrest are two different things.
Intimation of arrest is actually provided under the 36 only.
Yes, yes. And then your Lordship,
36.
kindly see page 61. This is the, they said that this is the grounds of arrest informed to the family members, but there is no signature of family members, Lordship.
Intimation is there, my lord. That I'll show it to your lordship through the affidavit, my lord.
And apart from that, Lordship, the language which they have used in section 48 notice is only provides, Lordship, for intimation of arrest. Why he was those grounds of our arrest are not there?
Okay, it may not be in name, but then no. But according to section 36, if there are no witness, then it has to be informed to the family members. Just give me BNSS next to the Arms Act. Yes. 36, right? 36 is... You see, section 36, clause C, subsection, yes, clause C. See, clause A and B talks of a proper name. B, prepare a memorandum of arrest, which shall be attested by at least one witness who is a member of the family or a respected member of the locality. Then 2, countersigned by the person arrested. Okay, then go to C. Inform the person arrested. Unless the memorandum is attested by a member of his family that he has a right to have a relative or a friend or any other person named by him to be informed of his arrest. So you have to inform the person arrested that he has a right to have a relative or friend to be informed of his arrest. Okay, that is not the case here, right? And if you say that, of course, the memorandum of arrest is not attested by any witness, right, then you have to inform the person arrested that he has a right to have a relative informed. Right. Here in your case, the memorandum of arrest does not contain the attestation. So in that case, C will come into play. So by C, he has to be informed that the relatives has to be informed.
So subject to correction, Lordship, section 36 B and C. In between, Lordship, the word used is and.
B and C?
Yes. The word after clause B, your Lordship will find countersigned by the person arrested and then C starts. It is not or. So
no,
witness
and,
signature
of course,
is
disjunctive,
witness signature is mandatory.
But you see, inform the person arrested unless the memorandum is attested by a member. So there is a condition given that if it is not attested by a member of the family.
Today I am not making submission on section 36, Lordship, because 36 is referred to larger bench, so that larger bench will address the issue. But here my case is, Lordship, that 48 notice was not served to the family members.
Acha, this 36 is referred to a larger bench?
Yes, Lordship.
Larger bench of High Court or what?
Principal bench.
Acha, High Court.
High Court.
Acha. Yeah, if you have, just give me the judgment.
Yes, Lordship. My local council will provide to the court master, Lordship, after some time.
So now you are on with 47-48.
Yes.
47.
Lordship, if I may, I'm not ready to argue on the merit now, my lord. That's my prayer. My prayer is, if I may kindly be granted time, my lord. I received it only recently, my lord.
Acha, page 58 is the grounds of arrest under 47.
I have also not gone through, my lord, the topic.
58.
58. And where is the grounds of arrest to the relatives? 61.
61.
Acha, Mr. Counsel for NCB, you see this grounds of arrest at page number 58? If you can show from here that full details are intimated, then if no case is made out against this one. See page number 58.
Yes.
There are enough details here.
No, contrabands were not recovered from my possession. It was recovered from other persons in the year 2024. I was arrested subsequently, Lordship, in the year 2025. So how I am connected, they have to disclose their fact.
That, my lord, have been duly shown in the charge sheet itself, my lord. So we have to be given time, my lord, for going through all this.
Okay. Learned counsel for the NCB appears, Mr. Heard also.
C. Joram Channel also.
C. Joram Channel, and also heard Mr. A. Ahmed, learned counsel for the petitioner. on the prayer made by the learned counsel appearing for the NCB. List this matter when? List this matter on 3rd of August?
3rd of August, Your Lordship.
3rd of August,
Third
Lordship,
of
it will
August.
be more than two weeks.
Yes, 27th of July.
Can it be, Lordship, on 25th? Can it be on 25th, Lordship?
No, my lord.
Because they have only to show that
I
whether
am not
that
available
notice
on
was served or not. Only that much.
Are you come back on 23rd of July? 3 days you get, you just have to see this.
No, my lord, no. 28, my lord. That dates, 2-3 days doesn't make any much difference, my lord.
Okay,
Please.
27th of July.
28, my lord, not on Monday, please.
No, you see, this is actually giving time is not proper. Because if he's saying there is violation, we have to release him forthwith. So 27th on Monday.
Problem.
Item number 17.
My lord, this is a criminal appeal against a conviction under the PC Act.
Mm.
And my lord, so here I am led by Mr. A.M. Bora, my lord. So.
Okay. List this matter before any other bench without me. Hmm? Yes. There are few passed over matters.
Item number 1.
My lord, I have inquired to the registry,
Mm.
and due to some technical reasons, the IA, which is for stay, was not reflected in the court list. Otherwise, the file is there, my lord.
File is there. I is there. Okay. Give me that. Achha.
My lord, for the respondent, I'll be private respondent. I'll be filing my objection.
Achha, what do you say about the stay?
I have to go through, my lord. I haven't.
He is praying for stay today.
For interim, he's praying.
Till next returnable date, you come prepare on the next date.
Yes, my lord.
Okay. Okay. Right. Heard Mr. C. Laltin Liama, learned counsel for the petitioner, and Miss
For the appellants, my lord.
Neema. Yeah, for the appellants. And Miss Neema or
Bilaram Nemi.
Nemi. Lalram Nemi. Nemi is a easier name to remember. Heard Mr. C. Thiang Lima. Lima and Leni. These are good. And then, and Miss Caroline.
I'm appearing for the state respondents number 2 to 4.
Miss Caroline answer for respondent number 2 to 4. What about 1?
I'm for the respondent number 1.
Oh, yes, she is for respondent number 1. The main respondent. Okay. This is a second appeal. Regular second appeal. Where is the petition, right? Second appeal, filed under section 17 within bracket 2 within bracket small b of the Mizoram Civil Courts Act 2005, read with section 100 of the CPC, challenging the order and decree dated 18/9/2025, passed by the Court of Additional District and Session Judge 3, Roman 3, Aizawl Judicial District, Aizawl, in RFA number 31 of 2024, full stop. It is the case of the petitioner or appellant. Oh, appellant. It is the case of the appellant that a civil suit, being civil suit number 83 of 2016, was filed by respondent number 1 There, what did they challenge? Where is the civil suit? Is it annexed?
I've annexed in the main appeal, my lords.
Huh.
That is from page 15.
15?
Yes, my lords. Their prayer is at page 22. Sorry, page 21.
15 you said?
In the appeal memo, my lords.
1-5.
Yes,
Yes.
1-5.
Okay.
Annexure
Hari.
1.
By respondent number 1, respondent number 1 is the person who had LSC.
My lord.
Yes, my lord.
1, praying for extension of the area of land covered by LSC number ISOL 1113 of 1986 by making correction of the area in figure as per boundary description written in the said LSC. In the said civil suit, respondent number 1 had also challenged the validity of the village council pass, being pass number 8 of 1974, allegedly issued to the appellant wherein the appellant had constructed a structure over the suit land. The said title suit was contested by all the parties and by order dated. What was the order date?
It's a judgment and decree dated 14/11/2024, page 32, my lord.
Page 32. By order dated 14/11/2024, the said title suit was dismissed.
Yes, my lords.
Was dismissed on various grounds referred therein. The learned court had framed 5 issues, and after deliberating on the same, dismissed the petition, dismissed the civil suit by the said order. Full stop, para. Against the said order passed by the trial court, respondent number 1 had filed a regular first appeal before the regular first appeal. Where is that?
It's from page 63, my lord.
63.
My lord. Before the district judge.
Before the district judge, Aizawl District, Aizawl Judicial District, Aizawl, Mizoram. And the learned court, Mizoram, registered as RFA number 31 of 2024. And the learned court, where is the order?
It's just after the index, my lords.
After?
After the index.
After the index?
Yes, it's the beginning of the appeal.
Oh, yes. By order dated 18/9/2025, had held that there were 2 surveyors' report, and one of the surveyor report, and in one of the surveyor report, it is stated that there is overlapping of land area covered by LSC number Aizawl 1113 of 1986 into the village pass, overlapping of
My overlapping of the LSC and my village council pass.
overlapping of LSC number so and so Diana and the village council pass allegedly possessed by the appellant, being village council pass number 8 of 1974. full stop. It is further held by the appellate court that the said village council pass was not valid inasmuch as the issuing authority, that is the village council, had issued the pass without the approval of the government as required during that juncture, or it is still required
During that period.
during that juncture. The court had also held that that the appellant had further admitted that the boundary shown in the LSC number 113 of 1986 should include some extended area. It is held that although the area shown in the LSC was 827.26 square meter, but it should be extended by another, there was some more, by another 616.22 square meter. And as such, the learned court held that some part of the land allegedly owned by appellant should go to the respondent number 1. After deliberating on various issues, the learned court, appellate court, had directed that that respondent number 1 is entitled for an additional area from the land held by the appellant. And that the respondent number 1 is entitled for a total area of 1143.48 square meter. And as a consequence to the said order, the appellate court had directed for demolition of the property erected by appellant on the said part of the suit land. Against the said judgment, the appellant had filed the instant second appeal before this court. Issue notice, returnable by 3 weeks. Ms. Nemi, learned counsel for learned counsel appears for respondent number 1, and Ms. Caroline appears for respondent number 2 to 4. There are 4 respondents, right?
My
4.
lord.
As such, no formal notice is required to be served on them, but extra copies be given to the said respondents by the learned counsel for the petition for the appellant within a period of 2 days from today. In the said facts and circumstances of the case, in the interim, this court directs that appellant, this court directs that only demolition I'm stopping, rest, okay, till the next returnable date. Only that part is required. What have you prayed in the
My lords, if my lords will see the decree passed by the first appellate court, it was also ordered that the state government shall make
before that,
necessary.
in the last line of the first paragraph, you write, in consequence to the said judgment and order passed by the appellate court, a decree was drawn up.
My lord, my lord.
On which date?
On,
It was not executed.
not yet.
Decree was drawn up
On 25/9/2025.
on 25/9/2025, which is yet to be executed.
I'm sorry, my lords. The respondent number 1 had filed an execution case.
Okay, they
Now
have filed, but it is not executed.
It's yes. I have the copy of the last order, my lords. If my lords
It
wants
is
to
not
peruse.
executed, although the respondent number 1 had filed an application for execution of the said decree,
Yes, which is registered as execution case number 115 of 2026.
which is registered as execution case number 115 of 2026.
My lord.
So in the interim, I'll only will not press on demolition of your property,
My lord.
of your land till
lord.
its next returnable date. Then on her objection or whatever submissions, we will consider on the next returnable date.
My lord.
Right. In the interim, it is directed the authorities not to demolish the house or what?
It's a house, yes, my lord.
Yes, not to demolish the house constructed by the appellant on his land, which is allegedly covered by Village Council Pass number 8 of 1974 till the next returnable date.
My lords.
Right.
And my lords, if the execution proceedings may be stayed, my lords.
Acha, yes, execution proceeding has full stop. It is further directed that till the next returnable date, the execution proceedings should not be conducted or the decree be executed.
I'm
List
deeply
this
obliged.
matter after 3 weeks on a date to be fixed by the registry.
I'm obliged.
Item number 2.
Or wait, what will I do in this? I stands disposed of. No. Yes. This is item? Okay. Yes, Hamar community. Yes, Miss Mary? Miss Mary? What I remember is that only 5.1 clause is left to be
Considered,
Yes,
yes.
considered. Others were all considered and it was all.
My lord, regarding 5.3, we'd like to say something.
5.3 is what?
5.3 is Government Administration Department Civil Subdivision was created, but in practical purpose, it is not functioning at all. PWD subdivision.
It is not created. The office is not there.
Created, my lord, but for practical purpose, till today, it is not functioning.
Where is the order? This
It is. They have
non-violation of which you have raised?
filed in my petition, my lord. It is in annexure.
Acha, page 11. 5.3, new civil subdivision will be opened at so-and-so and so-and-so of
It is
different
annexure number
department
page
will also
number
be established.
13, my lord.
Uh-huh.
Page number 13.
Or page number 13?
Yes, my lord.
No, I want to see the order of the this court. Will also be established at convenient location in the area, will also be upgraded. So, see the order, the violation of which you have raised, that is at page 11, I think.
Yes, my lord.
Right. Order dated 4/9/2017.
Yes, ma'am.
Yes. There you see 5.3. 5.3 was only with respect to opening the civil subdivision in that particular area. And
And the
subdivisional
subdivisional offices of different departments also be
established
at convenience
location in the area. So it has been established. Now, for what purpose and all this, you cannot press on this particular application.
My prayer is, my lord, if it is created for practical purpose, if it is not functioning,
No,
the
if
very
it is
purpose
created,
of est- the
no,
very
if it is
purpose of
created, it is
establishing-
not created for nothing. It will look into your grievances, whatever. What is this subdivisional office? To look into what?
for government administrative department.
So it has been established. It will look into. It will not just sit for idle. And this is the direction that it should be established. Now that it is established, it is complied with. Primary health center is also to be upgraded into
Yes, it
30
is
bedded.
upgraded.
It is done.
It
So
is done.
only 5.1.
And other department subdivisional offices, okay, they have created 4. But from the reply, so many subdivisional office still like excise and narcotic, RD, PHNE, environment, forest, climate change, horticulture, agriculture, UD and PA, these are not yet open.
Okay, we will not go into that. These are officers are there enough.
Before
So 5.1 only.
5.1, yes, my lord. 5.1, coming to the 5.1, if your lordship permit me, I will read through.
Yeah, I'll read that 5.1 once.
With a view to satisfying the desire and aspiration of the Mar community in Mizoram, the state government will initiate measures for use of Mar language as a medium of instruction up to primary level, and recognition of Mar language, one of the major language of the state of Mizoram. It is not confined to the Sindung Hill Council. It is within in the state of Mizoram. They have issued, they have filed one affidavit in March. From their affidavit, they had complied one recognition of Mar language, one of the major language in the state of Mizoram. But medium of instruction up to primary level in Mar language is not till today not implemented.
Where is the affidavit saying that? See, this court's order was after the settlement that has been reached between the parties. Right, the government
Yes,
of
my
Mizoram and
Mar
Hamar
People
People's Convention.
Yes, ma'am.
And these are not just court's direction for the first time. It is in consonance with the settlement reached between you and the government.
Yes, my lord.
So, exactly if I go by the strict sense of the term, there is no contempt actually. The court have ordered in consonance with the settlement that you have reached between the state and the Hamar community. So now the state is not agreeing to certain things.
Yes, my lord.
Acha, show me from the memorandum of settlement that I am holding at page number 15. Where are the settlement points?
This is the
That it will be a medium of instruction, where it is? Uh, 5.1, right. 5.1
Yes,
of the
5.1.
settlement.
yes, ma'am.
Satisfying the desires, the state government will initiate measures for use of Hamar language. Initiate measures, right? For use of Hamar language as a medium of instruction up to primary level and recognition of the Hamar language as one of the major languages. So recognition is done.
Yes.
Only you are saying that this
Medium of
initiating measures for
Mar language
as a medium of instruction is not done.
to primary level. Yes, ma'am.
Right. So, okay, show it from their affidavits. What is this memorandum of settlement? The next one, page number 26. Same one over. No, this is
From my lord, from the so-called reply filed by respondent.
no, I'm talking of the memorandum of settlement at page 26 of your contempt application. These are on separate issues.
Yes, my lord.
So the admitted fact is that Hamar people are more concentrated in the Singlung Hills Council, right? Because
no,
the
my lord.
next,
They
because
are
the
not only
next,
concentrating in the Sinlung Hill Council area.
in the next memorandum, it is seen so.
They are not concentrating only by a particular area, my lord, within the state of Mizoram.
Okay. Then,
From the rejoinder affidavit filed on March 2024 by respondent number 3 and 5.
this is an affidavit in opposition on behalf of state government.
Yes. In the annexure number 2,
No, this is the first affidavit in opposition. This was
so
filed on
reply on affidavit
9/9/2019. What does it say?
from March 2024 affidavit, so-called reply filed by respondent number 3 and 5.
You're referring to which affidavit?
So-called reply on affidavit
Yes.
filed
What
by
date?
respondent number 3 and 5, March 2024.
March 2024.
24, my lord. Yes, my lord.
Okay, yes. For respondent number 5.
Yeah.
Okay.
3 and 5. 3 and 5.
This is what March? This is 20, no, not March, 25/7/24. 15 March 24, you are talking of? Yes.
Yes, my lord.
3 and 5. What do you want to show from here?
From their annexure number 1, recognition of Mar language. Okay, they have notified. Medium of instruction till date not done.
Okay, this one has been complied with as a major language.
Yes.
Yes.
Medium of instruction till not done.
No. I'm talking of annexure 1 to that said affidavit. Page 194.
Yes, madam.
Here it is said that the governor of Mizoram is pleased to recognize Hamar language as a major language.
Yes, madam.
And that is done now.
Yes,
Then, what do you want to show?
Then only this one from 5.1. Medium of instruction up to primary level till not done.
Acha. Okay. Okay. Then,
And we have been waiting for almost 6 years. We have implemented already in this case 3 chief secretary and 3 home secretary. But till this is not implemented. Therefore, I would like to pray your lordship, do something for us. We have been waiting for almost 6 years. How many times they will file affidavits? So many times they will file rejoinder affidavits.
and what do they say about this other part? I mean, this medium of instruction part? What do they say in their affidavits? Okay, I'll come to Miss Maridel.
Yes, madam.
Yes. This is your submissions, Mr.
Yes,
Counsel?
madam.
Yes, what do you say on this?
Your Lordship, first of all, I would like to rely on one authority which I have not placed it in the first hour because I was a little bit handicapped in the morning. I was a little bit late. It's 2009 for SCC 213.
Okay, 2009 4 SCC.
For SCC 213. So
What
I
does
will
it
come
say?
to that.
Huh?
I will come to that later.
Okay.
Your Lordship, I will go into bits and details, but then I will not go on much because I have made a comprehensive compilation of whatever I would like to submit in my additional affidavit. So what happened is that this contempt petition arise out of writ petition number 80 of 2016, and it was disposed on 4/9/2017. 4/9/2017. Now, at the time of deliberation of WPC number 80 of 2016, the settlement of 1994 was enforced.
What settlement?
Memorandum of settlement between Government of Mizoram and Mar People's Convention.
Wait. Huh.
It is
Page number 14.
page number, it starts from page number 15 in my contempt petition.
Yes, 15.
It's dated 27th July 1994. Now, first of all, before I come to
1994.
1994.
Okay.
Now, this clause 5.1 and 5.3 arose from the settlement of 1994. And Your Lordship, if I may take Your Lordship kind attention to the affidavit, additional affidavit, which I have
Dated?
filed.
Dated?
It's the recent one, Your Lordship.
Achha.
Respondent number 5.
27. 25/7.
Yes.
24.
Not 24.
Not 24. It is 24 only.
It should be 25.
Additional affidavit.
Yes.
Yes, 29 July 25.
Yes, that one.
Yes.
If I may take Your Lordship kind attention to page number 20,
No, wait 1 second.
lecture 2.
Page number 20 of that affidavit.
Yes, 20 of the
Yes, this is the MOU, Memorandum of Settlement.
Yes, memorandum of settlement between the Government of Mizoram and Mar People's Convention.
2018.
2018, and if I may take Your Lordship kind attention to page number 24.
Memorandum.
Page number 24, clause 7.2.
Enhanced authority to Singlung Hills Council.
Yes, the relevant portion that I would like to refer is, and in furtherance, the memorandum of settlement signed between the Government of Mizoram and Mar People's Convention HPC on 27 July 1994 shall stand superseded. Now, it already stands superseded. It is not enforced anymore. But admittedly, what the government did not do was that we do not file the review petition to incorporate this. That fact I admit. And that is why, for ends of justice, we were ready to comply, and we did comply with the direction of this honorable court, which says that as per the 1994, like I have submitted, this case was disposed of in the year 2017. 2018, 1994 stands to superseded. Now, this do not have any force in fact. And
But the court's order is there.
court order is there. So for ends of justice, we intend to go ahead with the order, because for ends of justice and for the benefit of the welfare of the Mar community. And clause 5.1 read, we should read this very carefully, Your Lordship. Page 11 of my, page 14 of my contempt petition. it says with a view to satisfying the desires
Wait,
and
I'll just
aspirations.
take out the
Yes,
this one.
because we have to read between the line.
Yes, wait, 94, yes.
We have to make some initiation or measures for use of Mar language as Mar language as medium of instructions to primary level. That is one aspect. Second aspect is and recognition of Mar language as one of the major language in the state of Mizoram. Now, clause 5.1, according to my understanding, it has two tiers. That one is the state government will initiate measures for use of Mar language as medium instructions up to primary level. That is one aspect. Second is recognition of Mar language as one of the
That is
major
also
language.
initiate measures.
Yes.
Initiate
In this-
measures for recognition.
one of the major language of the state of Mizoram. Now they are trying to interpret, because the contempt court is not a court for interpretation. Now they are trying to interpret the settlement that was made, even though the court did not make an effort while disposing the WPC 80 of 2006. It was not in dispute. This was not in dispute. So now at this contempt stage, they are trying to interpret the 1994 clause 5.1 into saying that will initiate measures of Mar language as medium instructions up to primary level in the state of Mizoram. But that is not the wording of the clause 5.1. Because 5.1 have two tiers, like I have submitted. It does not say, it does not mention any geographical boundary as to where it should be used or measures should be taken. Now, considering that, yes, my learned friend is Mar, and yes, my learned friend here also is Mar. She don't speak Mar language though. But they are settled in different part. Admittedly, they are settled here in different part of Mizoram. But then, admittedly, my learned friend, the highest concentration of Mar people is in Sinlung Hills. And that is why they have this People's Convention, etc., in that hills alone. Now, in compliance with this honorable court and taking initiative measures for recognition of Mar language or as medium of instructions, several meetings was held, which I have already incorporated in my affidavit. I have already taken your lordship kind attention. I can take your lordship kind attention to it again. If I may take your
So what
lordship,
you mean to say is you had initiated the process.
we have initiated, we have taken up the measures. And I will come to that. We have taken a full-fledged measures so as to comply with
The
this.
direction is not that you initiate measures and you do it.
No,
That is not the direction here.
The direction of this honorable court is state respondents to comply with clause 5.1 and 5.3 of memorandum of settlement. That's it. No interpretation of the clause at all. The direction was very simple for
Initiating
compliance. Yes, for compliance of 5.1 and 5.3 clause of the memorandum of settlement. Now 5.1 read will initiate measures for use of Mar language. I'm not going to the other issues. I'm not going to the other issues because it is already been settled and it's already written and recorded by this honorable court. If they are not, if they are aggrieved and come to say that we are aggrieved with 5.3 again of the actions taken, then they can file another writ petition also. And Your Lordship, in taking, in compliance of this honorable court order, we have taken an initiative measures. Now coming to Your Lordship, if I may take Your Lordship kind attention to page 25 of my additional affidavit, which I have referred, the July 2025 affidavit.
Page number, what you said?
Page number 25.
The recent affidavit, right?
Yes, the recent
Page number
affidavit.
25, yes.
So these, as compliance of this honorable court, meeting was undertaken by the chairmanship of so-and-so minister held on 17th October 2017. Now, in the paragraph number 2, the issue regarding clause 5.1 of memorandum settlement between so-and-so use of Mar language as medium of instructions up to primary level and recognition of language as one part of the major language of the state of Mizoram. After careful deliberation and discussion, it was decided that Director of School Education will conduct survey to ascertain the feasibility and implementation of the 5.1 clause as per court's order dated so-and-so. And the DEO was to submit the proceedings of the meeting to the government for further consideration. Now, in furtherance of compliance...
No, so careful discussion was decided that department will conduct survey.
Yes.
To ascertain the feasibility of implementation of 5.1.
Yes. So,
see, feasibility you are yet to decide. Right, you have to conduct
I'm
survey.
coming to that. I'm coming to that. That is only the at the time of initiating measures, the first step. Now, coming to, we have taken
without
several
taking
steps.
those steps, how can they enter into a settlement between the government and the so-and-so?
Yeah.
There has to be something undertaken before settlement at all. I'm not talking of court's order. The settlement that was reached between the Hamar and the government, without initiating anything, they have simply decided on that. And thereafter, these measures are being taken up.
These measures are taken up after the settlement.
This is also not very correct.
And Your Lordship, in page number 26.
After that, the survey report be discussed. After the survey is done.
Yes.
It has to be discussed by convening a meeting
Yes.
along with concerned DEO and submit the proceedings to the government for further consideration.
Yes.
Okay.
And Your Lordship, in 2020, meeting was convened by the...
which page?
Page 26, the subsequent page. And the second paragraph, the meeting resolved that a joint meeting to discuss implementation of 5.1 Memorandum of Settlement to be held with representative of Sindung Hills Council and accordingly fixed so-and-so for the set
So
meeting.
survey done?
Yes.
Where is it that survey is done?
Your Lordship, I have not annexed, but I have not annexed, but then...
so it seems the survey was done and thereafter this meeting took
Yes,
place.
yes.
So the
After
meeting
3
was
years.
convened and chaired by so-and-so. The meeting discussed the directions of the government of the Gauhati High Court for implementation of 5.1 use of so-and-so. The meeting resolved that a joint meeting to discuss implementation of 5.1 be held with representative of Singlung Hill District and accordingly fix so-and-so. Okay, another joint meeting to be
Yes,
held.
yes. In page number 28. 27 is just a meeting notice. And
meeting notice in respect of 5.1, right?
yes, in respect of 5.1. And Your Lordship,
This is joint meeting.
Joint meeting present. The members present are in serial number 5, 6, 7, 8. They are all representatives of the stakeholders of the Sindung Hills Council.
Okay.
And
then 28.
English translation is in 29, page 29. And fourth paragraph, start from second paragraph, Your Lordship. Upon request of the chairman, officials of SHC delivered their opinion and thanks to the government for conducting such conducive meeting with the council for the first time and expressed importance of preserving Mar language and concerned the use of Mar language as one of the subject up to primary level. The meeting agenda so and so as medium of instruction was broadly discussed with mutual understanding from both sides of episode. The pros and cons was also discussed at length. After careful discussion, the meeting resolved that Sindung Hills Council will have consultation with Mar community at large. This to have the concrete decision, and it will be discussed on so and so in the chamber of the minister. So Mar community was through the Sindung Hills Council was and Your Lordship, on 22nd 2020
30
page 30, yes, serial number 4 and 5 are the representative of Sindung Hills Council. And Your Lordship, I'll just jump to the serial number 1. Sorry, I'll start from the second paragraph. So and so Education Minister, Chairman of the meeting, welcomed the members. He highlighted the purpose of convening the meeting by recapitulating meeting resolution already passed in the previous meeting held on so and requested officials from Sindung Hills to report the outcome of the consultation between the council and the Mar community. Accordingly, officials of Sindung Hills Council submitted their report as follows. Number 1, Government of Mizoram may issue notification for implementation of Part 5.1 MOS 1994 and conduct joint meeting with so and so to have consultation with Mar community regarding implementation of Mar language as medium of instructions. Representative of Mar were present in the meeting desired that Mar language to be introduced as major Indian language and taught as one of the subject to high school level.
From primary to again high school.
Yes, yes. After lengthy deliberation and discussion, the meeting unanimously resolved that notification be issued by government regarding Mar language medium instructions of primary level with 5.1 memo as per the direction of this honorable court. Now, it does not say that as per it does not say that in the state of Mizoram. It says that it's in line with paragraph 5.1 of memorandum of settlement and as per the direction of this honorable court. And necessary will be taken up by the government in consultation with the Sindung Hills Council. The meeting also reiterated that as per the government allocation rule, the purview of school education regarding 5.1 settlement is limited to use of Mar language as medium of instructions as to primary level only, whereas remaining clause of sentence is concerned with other departments. Now, the submissions that may have made after consultation with the Mar community, the subclause 2, the paragraph number 2 was not considered because as major Indian language that is beyond the scope of the school education department of Mizoram.
So nothing material came up in the meeting, only that you have to discuss it.
Yes, but then
Further follow-up action.
I'm just showing that Mar community were consulted, duly consulted and represented in taking the measures, in taking the initiatives also. And notification dated 29 October 2020 in page number 32 was notified that says that shall be used as medium of instructions up to primary level within Sindung Hills Council area, and all necessary follow-up action will be taken by the government in consultation with the Sindung Hills Council. So notification was held.
So this notification was issued to show that
notified.
It is hereby
it was
notified.
and measures was taken.
Shall be
initiative
used
measures.
as so within Singlung Hill Council area.
Yes, within Sindung Hills Councils. Now they are arguing that it only says that Sindung Hills Council, but then nowhere in 5.1 says that it should be stretched into whole state of Mizoram. It just says that shall initiate measures for use of Mar language as medium of instructions in primary up to primary level. That is the first point. Second is, and for recognition of Mar language as one of the major language of the state of Mizoram, Now, if it is supposing if it is the case wherein they sought for interpretation of the 5.1 clause, then I would say that it should be read as it shall initiate measures for use of Mar language up to primary level in the state of Mizoram. Now the wording, if we read carefully, the second condition is that the recognition of Mar language as one of the major language of the state of Mizoram, not in the state of Mizoram, of the state of Mizoram. Now, reading again, Your Lordship.
But then, okay, but that's a question of interpretation whether that state of Mizoram
Yes,
will
yes.
be read
But
in
then
both
they
the.
are into that. They are
Uh-huh.
into that, and that is beyond the scope of the contempt court. First of all.
Yes, and moreover, after this order was issued, was passed, there was so many deliberation with them.
So
At
many
that time, they did not raise this.
And that it does not end there, Your Lordship. It does not end there. After notification, to comply with this honorable court in true spirit, in its true spirit, we have yet again, if I may take Your Lordship kind attention to page number 33 of the affidavit, additional affidavit. I'll come to second paragraph. So and so, chairman of the meeting welcomed the members. He highlighted upon the members for the purpose of convening the meeting is to be considered course of action to be taken for adoption of Mar language as medium of instructions up to primary level within Sinlung Hills Council area in terms of 5.1 of Memorandum of Settlement 1994. After lengthy discussion, the meeting resolved that action be taken for preparation of textbook of class 1 to 4 in Mar language. Translation textbooks be carried out so and so. So we have
But
made a
here,
textbook.
here you have included one more thing within Singlung Hill Council.
Yes, yes.
Which was of course not there in 5.1.
Yes.
And joint meeting with Singlung Hills Council
But
to
then
discuss
that is
the matter.
after the consultation with the Mar community. This all
As well
these
as
things.
Singlung community
Yes,
representatives.
Yes, yes. Sinlung Hills community do not make their decision based on their ideas alone, but Mar community were consulted. And Your Lordship, after that we have made this kumtuang for use of the Mar community in Sinlung Hills District Council. But as I have submitted, Your Lordship, we have already printed and ready for use. If I may take Your Lordship kind attention to page number 11 of my affidavit.
Same affidavit.
Same affidavit.
Yes, page number 11. Yes, these are the pleadings. Okay,
And-
government issued a work order for printing of elementary school textbooks.
They have printed work order for printing. Among these were textbook titled Kumpuang to prepared by Mar with as a medium of instruction. The Mar community has expressed a preference not to use these textbooks, and consequently it has not distributed for use.
So what is their objection? Not for the state.
They do not, I don't know the clear instructions in this, but then the Mar community in Sindung Hills area do not want to use the Kumtuang, even though it is
Now he will have the instruction. Why they did not?
No, we are not. This regarding the use, no information. was- No, I mean, the Mar community is not consulted in this. Madam.
But then they were there in the meeting.
Yes, Your Lordship, anyway, we have gone to that extent. We have to go on to that extent whether this is a fact on oath we have submitted, because even the textbooks is lying there in the office, which they refuse to use. So if they want to approach the court by way of another writ or any suit, we can produce as an evidence also, because we have the order, we have the books lying there unused. So that is there. And anyway, that is another issue.
Otherwise, Mr. Counsel, contempt as such will not lie.
Yes, civil contempt.
There is no violation, willful, deliberate violation of this order, because they had taken initiatives, they have taken steps. And your person was there in the meetings. Singlung representatives were there, Hamar community representatives were there. And then they reached to a particular conclusion. Books were printed. Then they said they will not use. So what I will do is close this contempt, and you again initiate with the government. Because, and at the end of the day, you see, this court's order was also based on the settlement reached between you and the government. Court has got nothing to do. It has just reiterated. So there is no contempt. You do one thing, you just, I'll make that order. You again, if you have some grievance, you again speak to the government and reach a settlement. Settlements are being reached every now and then. 94 is superseded now.
Yeah, my lord, in this regard, 1994 settlement, I would like to.
94 is also superseded
My
by
lord, let me say
2018.
1994.
Your Lordship, just one
Acha,
more
let her
submission.
finish.
Ah,
I've
just
just
one more submission. Now, when this matter, like my learned friend have submitted, this matter has pending for more than 6 years. And again, new ideas come in, and then new submissions and reiteration or submissions on in conflict with the earlier submissions. Now, in 25/2024, my learned friend was present before this honorable court. It was, Your Lordship, 25/2024.
This court order.
This court order. In the contempt case. My learned friend, he himself have submitted that the learned counsel for the petitioner submits that show cause reply affidavit filed by 3 and 5 in terms of judgment and order dated so and so have complied with clause 5.1 of Memorandum of Settlement executed between the government and Mar People's Convention. It was submitted by
Which order? Which order? Let me see.
25/2024.
25.
2024. The order is
24.
there. Yes.
25/24.
25/2024.
Yes.
Heard so and so learned counsel. This is the name of my learned friend. The learned counsel for the petitioner submits that in the show cause reply filed by respondent number 3 and 5 in terms of judgment and order dated so and so passed in so and so. The state respondents have complied with clause 5.1 of Memorandum of Settlement executed between the government of Mizoram and Mar People's Convention. However, 5.3 is yet to be complied with. So that was his own submission. Now, again, in the last court date, 11/6/2025, my learned friend have submitted that the state have considered that we have complied with 5.3. Now, the only deliberation that needs to be is 5.1. Now, again, this day, today, my learned friend came again complaining about non-compliance of 5.3. So this is just an afterthought and some innovations in the mind. Now, civil contempt, as you know, Your Lordship knows it and have already pointed out it to my learned friend. It only goes to if only contempt can be proceeded only when there is deliberate negligence or disobedience or willful disobedience, etc. My learned friend nowhere from day one for 6 years till date have not shown that there is deliberate willful disobedience, because what we have shown this court is just in compliance with the order of this honorable court only. So contempt proceedings cannot be proceeded in this case, Your Lordship.
Yes, you wanted to show something?
Yes, my lord. Regarding 1994 agreement, 27 July 1994, my learned friend said, this 1994 agreement is memorandum of settlement between Government of Mizoram and Mar People Convention, HPC. HPC, Mar People Convention. 2018, 2nd April 2018 is memorandum of settlement between Government of Mizoram and Mar People Convention. Democratic, they are other party.
So in the meantime,
1994 is Mar People Convention, HPC only. 2018 is 1994 other party. It is.
and that is your parties.
No, it is
Segregated
our party,
between
my
2,
lord.
3.
Yeah,
But the fact remains it is for the Hamar community only.
My submission is our WPC is 1994 agreement between Government of Mizoram and Mar People Convention. During the pendency of this writ petition, the Government of Mizoram signed Mar People Convention democratic with other party and
No,
they
not
have
not during pendency. It is
After the disposal.
Because see, the order was of 4/9/2017, and this was later.
2018.
WPC 80 of 2016 was filed on 4th September 2017. and judgment was delivered. Then another for contempt petition we have filed. Then after filing the contempt petition 20 of 2018, the court instructed to file a representation. Representation for compliance. Notice of compliance.
Where is the order of contempt case 20 of 2018? Where is the order? Same. This is 20 only.
Page
Contempt
number,
case 20 of 2018.
Contempt case 7 of 2019.
Acha, this is not passed in writ petition. This was in contempt case.
Yes. Previously WPC 80 of 2016. Then we have filed contempt case number 20 of 2018. Then your lordship have directed us to file representation.
Wait one second.
It is in page number
Petitioner was
15, madam.
submit that he may be allowed to. Then, what do you want to say?
Then, as per this order 20 of 2018, dated 9/10/2018,
So you were given the liberty to file a representation as we had prayed
yes,
for,
we have filed.
and it was closed.
And we have filed representation. But still not complied. So this contempt petition 7 of 2019,
Acha, okay. Your representation was not considered.
not considered.
So you had filed 7 of 2019.
7 of 2019.
Yes.
And regarding 1994 agreement, it is between Mar People Convention and 2018, which some other party, the government is superseding.
Some other party means
Anyway, Your Lordship, we do
Mar
not
People
press on that
Convention
because we are
Democratic.
complying with the 1994 memorandum of settlement only. So that admittedly, I
that's
have submitted.
only a passing reference that she
Yes,
said.
it was just a passing.
Okay, I'll dictate the order, huh? I heard Mr. Neichunga Darlong, what's her
Yes,
name?
madam.
Neichunga Darlong, learned counsel for the petitioner, and Miss Mary L. Khiangte, learned counsel for respondent number 3 and 5.
All the respondents, yeah.
Appearing for all the respondents, huh? This is a contempt application filed under section 11 and 12 of the Contempt of Courts Act. You can see both the counsel said.
Your Lordship,
This will take some
the
time.
citation that I have referred.
94 SCC.
Yes.
What is that? What does it say?
94 SCC, paragraph number 6, several judgment authority was relied upon by the Honorable Apex Court. And under para 63, page 217, the court held that Contempt of Court Act has been introduced in the statute book for securing confidence of the people in the administration of justice. If an order passed by the competent court is clear and ambiguous and not capable of more than one interpretation, disobedience or breach of order would amount to contempt of court. There can be no laxity in the situation because otherwise the court orders would become the subject of mockery. Misunderstanding of understanding of the court's order would not be permissible as defense. So what I would like to say is that when there is, maybe they are saying that in the state of Mizoram, we are not saying that there is no geographical indication. So there is no clear or ambiguous order because the order is just for compliance of 5.3.
Okay. This contempt application was filed under section 11 and 12 of the Contempt of Courts Act 1971, read with Article 215 of the Constitution of India. Full stop. The petitioner has raised that there is disobedient of the order dated 4/9/2017 passed by this court by the respondents. full stop. By the order dated 4/9/2017, this court had disposed of the writ petition, that is WPC number 80 of 2016, on the basis of the memorandum of settlement entered into between the government of Mizoram and Hamar People's Convention. Hamar, HMAR, People's will be apostrophe S Convention, within bracket HPC, on 27th of July 1994. It was held that by the said settlement, few clauses were inserted for the compliance thereof by the state respondents. And they are clause 5.1 of the said settlement, which states that in order to satisfy the desires and aspirations of Hamar community in Mizoram, the state government to initiate measures for use of Hamar language as a medium of instruction up to primary level, and recognition of Hamar language as one of the major language of the state of Mizoram. Full stop. Apart from the same, another clause was also entered into, another agreement was also entered into between the state and the Hamar People's Convention, that a new civil subdivision will be opened at Sakaur-Dai, SAKAWR-DAI, and the subdivisional offices of different departments will also be established at convenient location in the area. Full stop. It was also agreed that the primary health center at Sakaur-Dai, the same place, Sakaur-Dai, will also be upgraded into 30-bedded community health center. Apart from other, full stop, apart from other agreements, these agreements were also entered into between the government of Mizoram and the Hamar People's Convention. And on the basis of the said agreements, the aforesaid writ petition was disposed of on 4/9/2017 with the direction that the state respondents should comply with clause 5.1 and clause 5.3 of the memorandum of settlement. Full stop. It was also directed that the state respondents should comply with the said agreements within a period of 1 year from the date of receipt of the certified copy. Full stop. Para. In violation of the, it is stated by the petitioners that the said order dated 4/9/2017 was not followed, and a contempt application was filed, being contempt case number 20 of 2018. Full stop. This court, by order dated 9/10/2018, passed in the aforesaid contempt application had directed, on the basis of the submissions made by the counsels for the petitioners, the directed the petitioners to submit a representation for compliance of the order dated 4/9/2017, passed in WPC number 80 of 2016. আচ্ছা এই ডাইরেক্টেড বুলি যে ক'লো লাইনটোত the learned court directed the petitioners লিখি দিয়াচোন তাত directed the petitioners on the basis of the submission made by the petitioner to submit a representation. Okay. The learned counsel for the petitioner submits that in compliance of the said order dated 9/10/2018, the representation was submitted, but the same was not disposed of by the government, by the authorities in the government. And in pursuance thereof, the present contempt case, being contempt case number 7 of 2019, is filed. The learned counsel for the petitioner submits that as far as the other agreements are concerned, which were provided in clause 5.3 of the memorandum of settlement, as well as in the order of this court, the civil subdivision was created at Sakaudai, and subdivisional office of different departments were also established at convenient locations. And as such, he submits that the said clause was complied with, said direction, that the said direction to comply with the said agreement was complied with, but I'll give you another word, is, what do you have, some other word for comply? Okay, I'll change it, complied with, full stop. He also submits that other direction, as per the agreement entered into between the parties, that health center at Sakaudri should be upgraded into 30-bedded community health center, the same was also complied with by the authorities concerned. The only, full stop. The learned counsel also submits that a notification was also issued in pursuance to the second part of the clause 5.1 to the effect that Hamar language was recognized as one of the major languages of the state of Mizoram. Full stop. The only grievance that the petitioner has raised in the present proceeding is that the Hamar language has not been used as a medium of instruction up to primary level. In the state of Mizoram. Full stop. The learned counsel vehemently argues that till date, the said language has not been provided as the medium of instruction up to said primary level. Full stop. Para. Miss Mary L. Khyangte, Learned Counsel for the respondents, however, submits that the requirement under the memorandum of settlement as well as under the court's order is that the government, the state government, should initiate measures for use of Hamar language as a medium of instruction up to primary level. Full stop. She submits that in the said clause, it is not provided that medium of instruction up to had not stated that Hamar language should be used as a medium of instruction up to primary level in the state of Mizoram. She submits that the state of Mizoram is only referred in the second part of clause 5.1, which says that Hamar language should be considered as one of the major language, should be recognized here, should be recognized as one of the major language of the state of Mizoram. And she reiterates that the first part of clause 5.1 does not say the same should be made in the state of Mizoram. Full stop. She also states that the initiative measures which were directed to be taken as per clause 5.1 was in fact taken by the state respondents. No, by the respondents, not state, by the respondents, by holding various meetings to that effect. She has placed the affidavit filed by respondent number 3 and 5 29 July you said, right? This is the affidavit.
Yes, Your Lordship.
Filed on the affidavit, relied on the affidavit filed on 29th of July 2025 in the present proceeding. Courtmaster, just tell him to bring some water for me. Filed on so and so, right? At the outset, she has placed the memorandum of settlement entered into between Government of Mizoram. Oh, no, wait. No. Government of Mizoram and Hamar's People Convention Democratic will be in bracket, Hamar's People's Convention, Hamar People's Convention within bracket democratic entered into so and so on 2nd of April 2018, wherein it was agreed between the parties that the said settlement was reached and the earlier settlement dated 27th of July 1994 stood superseded. The same was provided at 7.2 of the said settlement. Clause 7.2 of the said settlement. She, however, stated that on 16th of October 2017, at about 1 p.m., a meeting was held with officers of the school department and the Honorable Minister, a meeting was held under the chairmanship of the Honorable Minister of the School Education Department with the officers of School Education Department. And in the said meeting, implementation of clause 5.1 was dealt with. And it was decided that the Director of School Education Department will conduct a survey to ascertain the feasibility of implementation of clause 5.1 as per Court's order dated 4/9/2017. Full stop. It was further resolved that after the conclusion of the survey, another meeting should be held with the concerned DEOs and SDEOs and the proceedings of the said meeting was directed to be submitted to the government for further consideration. In pursuant to the same, full stop, in pursuant to the same, and in pursuant to the survey done, another meeting was held on 30/9/2020. After 17 to 2020, there were no other meetings, right? It took time. Okay, 30/9/2020. Another meeting was held on 2020. 30/9/2020. Wherein the implementation of clause 5.1 was again discussed, and it was resolved that a joint meeting to discuss the implementation of the same to be held with the representatives of Singlung Hills Council, and accordingly a meeting was fixed to be held on 7/10/2020. In pursuance to the said resolution, a meeting notice was issued on 1st of October 2020, wherein the members of the committee were constituted. Members of the committee was is scheduled to be held on so and so in the office. Okay. The resolution. A committee was formed by meeting notice a committee was formed with the members mentioned therein for the meeting to be held on 7/10/2020 in the office of the Minister of School Education Department. Full stop. In compliance with the same, a meeting was held in the chamber of the Minister of School Education on 7/10/2020. And in the said meeting, the representatives from the Singlung Hill Council was present, and it was resolved it was resolved, and an agenda was made to the effect that use of Hamar language as a medium of instruction up to primary level within Singlung Hill Council's area. The said subject was broadly discussed. And it was resolved that Singlung Hill Council, representatives of the Singlung Hills Council, will have a consultation with Hamar community to have a concrete decision. And after the said consultation, a meeting was scheduled to be held on 22nd of October 2020. What about water? Water. তারপরে কি করলো? So it's a full stop. On 7th, in compliance of the same, a meeting was held on 2nd of October 2020. And in the said meeting, request was made to the officials from Singlung Hills Council to report the outcome of the consultation held between the council and the Hamar community. And in reply to the same, the Singlung Hill Council submitted its report. Kikulu submitted its report, right? It was stated in the report that the government of Mizoram may issue notification for implementation of para 5.1 of the Memorandum of Settlement entered in the year 1994, and to conduct a joint meeting with the petitioners in the original writ petition being WPC number 80 of 2016. Full stop. It was also stated that the said petitioners may have consultation with Hamar community regarding implementation of Hamar language as medium of instruction. Full stop. It was also stated in the report that the representatives of Hamar community who were present in the meeting. Acha, this Hamar community people were present in 7th October 2020 meeting, Miss Mary. This Hamar community were present in, no, they were not present.
No, Your Lordship, the Singlung Hills Council
they were
representatives
present.
are there, but then Singlung Hills Council have consulted
I have
the Hamar
consulted.
community.
Yes, this is there. But see the second point in the said meeting, representatives Hamar community who were present in the meeting. That means the earlier meeting, consultation meeting.
Yes, consultation
Achha.
meeting.
Okay, it further stated that the representatives of the Hamar community were present. Were present. The representative of Hamar community further suggested that Hamar language be introduced as major Indian language and taught as one subject from primary to high school level. Full stop. On conclusion of the said meeting, it was resolved that a notification should be issued by the government regarding para 5.1 of the Memorandum of Settlement 1994 as per direction of the Honorable Gauhati High Court, and that necessary follow-up action to be taken in consultation with Singlung Hills District. It was further reiterated in the said, it was further resolved that as per the suggestion of the Hamar community, that Hamar language has to be used as major Indian language up to high school level was is of the concern of other departments, and that the said meeting was only in connection with the order passed by this court. The learned counsel for the respondents further submits that a notification was issued on 29th of October 2020 by the government of Mizoram notifying that Hamar language should be used as medium of instruction up to primary school within the Singlung Hills district. Full stop. She further submits that on 11th of March 2021, a meeting was again held for implementation of the High Court's order, wherein the officials of both Singlung Hills Council and the School Education Department were present. And after a lengthy discussion, it was resolved that action be taken for preparation of textbooks for class 1 to 4 in Hamar language. Full stop. She, however, submits that the textbooks were prepared, but where is the pleading you said?
11,
Page
Lordship,
11.
para 10.
Were prepared, but the Hamar community expressed preference not to use this textbook, and as such, the said textbooks were not distributed for use. She submits that there is no willful or deliberate violation of the court's order dated 17/9, court's order dated 7/10/2017. No. Court's order dated, which was 19 order? Oh no, 18. Violation. Court's order dated 4/9/2017. Okay, goes no. 4/9/2017. She submits that enough steps were taken for compliance of clause 5.1 or clause 5.1 of the settlement, of the memorandum of settlement, / para 5.1. No. Clause 5.1 of the memorandum of settlement as well as the High Court's order. And the textbook were also printed, but the same were rejected by the Hamar community. To substantiate her argument, she has placed reliance on a judgment delivered by Supreme Court in 2000. I'll take out. What is the party's name? Delivered in. It's okay. I'll take out from here.
C. Elumalai and others versus AGL Yerudayaraj and another. 2009 for SCC 213. 213.
213.
213.
Yes. In C. Elumalai, C.ELUMALAI and others versus AGL ... AGL Irudayaraj, IRUDAYARAJ and others. Reported in 2009 4 SCC 213. Wherein the Apex Court had held which paragraph you said?
Your Lordship, under paragraph number 6, 6 more paragraph 63. Page 217.
There is no 63 here.
Page 217.
No, there are very small paragraphs. There are very few paragraphs there.
In Anil Ratan Sarkar versus Farid Ghosh. This court held that contempt court has been introduced.
In some referred case?
Yeah, some referred
in
case.
Anil Ratan Sarkar? Okay. Wherein the Apex Court, by relying on an earlier decision in Anil Ratan Sarkar versus Hirak Ghosh, held that if an order by a competent court is clear and unambiguous and not capable of more than one interpretation, disobedience or breach of such order would amount to contempt of court. And that and the said order should not be amenable to should not be amenable to any other interpretation. She submits, by relying on the said judgment, that paragraph 5.1 of the settlement does not speak that Hamar language should be used as a medium of instruction at up to primary level in the whole state of Mizoram. Full stop. These are your submissions? Right.
In the whole state of Mizoram and the direction of this the Honorable Court while passing WPC 80 of 2019 was to the extent that 5.1 and 5.3 clause should be.
This I've already said.
Yes, that's it.
She reiterates that the direction of this Honorable Court was only for compliance of clause 5.1 and 5.3 of the settlement, and she further submits that all other agreements between the parties have been complied with, and in respect of 5.1 and in respect of first part of the 5.1 of clause 5.1, the same which requires steps to be taken for use of Hamar language as medium of instruction at primary level, the same has been done as was stated above. Full stop. This is 1 o'clock. I'll dictate the rest. Okay. Not at 2, I'll take up Mr. Medhi's matter. I'll dictate that in the chamber.
Yes.
Okay. Okay, I can continue. Yes, Mr. Medhi, I'll take up my matter at 2. Okay. Okay, rest of the I will do it. I have heard the counsels. Narendra, after 10 minutes. I have heard the counsels and have gone through the relevant documents of the instant case. It is seen that the government of Mizoram and the Hamar People's Convention HPC had entered into the settlement on 27 July 1994, and it was decided on the following aspects. I'll just quote here from here to 5.1 to 5.4. Full stop. The writ petitioners had filed a writ petition, that is WPC number 80 of 2016, with the prayer that clause number 5.1 and 5.3 were not exercise under clause 5.1 and 5.2 were not done. Were not done. And as such, the said writ petition was disposed of with a direction that the government should comply with the clause 5.1 and 5.3 of the said memorandum of settlement. Full stop. It is also noticed that for non-compliance, for the alleged non-compliance of clause 5.1 and 5.3 of the said settlement, the petitioners filed the contempt application, being contempt case number 20 of 2018. And the High Court had disposed of the contempt petition by giving liberty to the petitioners to file a representation, to which the petitioner submits that representations were filed, but the same were not considered. And a subsequent contempt application was filed before this court, that is the instant one. The full stop para. It is the considered opinion of NLI. The direction given both in the memorandum of settlement, the direction given in the order dated Now, 4/9/2017 were to the effect. 4/9/2017, which was on the basis of the memorandum of settlement, which was strictly on the basis of the memorandum of settlement, provided that the state government will initiate measures for the use of Hamar language as a medium of instruction up to primary level, and also for recognition of Hamar language as one of the major languages of the state of Assam, the state of Mizoram. Full stop. The directions were also given for opening of civil subdivision at Sakardai and subdivisional offices of different departments to be also established in the area. And the health center of Sakardai be also upgraded to a 30-bedded community health center. Full stop. It is seen that all other requirements are fulfilled, barring the first part of clause 5.1, which provided as mentioned above. Full stop. It is also noticed that pursuant to the said order, various meetings were conducted by the state respondents. And in the meeting, held on 30/9/2020, it was resolved, as stated above, that a joint meeting was to be conducted with representatives of Singlung Hills Council. Full stop. There is nothing on record to show that there was any objection with regard to the meeting held with the representatives of Singlung Hills Council only, and not any representatives of other places in the state of Mizoram. Full stop. In accordance with the said resolution, the officials of the subsequent committee was formed with the representatives of Singlung Hills Development Council. Full stop. In the subsequent meeting of the state respondents with representatives of Singlung Hills Council, it was decided that the said representatives will have consultation with the Hamar community, and a decision was directed to be conveyed in the said meeting, in the next meeting. Full stop. Thereafter, in the next meeting, the representatives of the Singlung Hills Council submitted its report after consultation with the Hamar community. And in the said report, it was not stated that Hamar language should be used as the medium of instruction in the whole state of Mizoram. Rather, a report was submitted wherein Government of Mizoram was given liberty to issue notification for implementation of 5.1 of the Memorandum of Settlement, and to have a joint meeting with the petitioners and to permit petitioners in original writ petition being WPC number 80 of 2016, and to permit the said petitioners to have consultation with Hamar community regarding implementation of Hamar language as medium of instruction. Further, it is seen, in pursuant to the same, a decision was taken and a notification was issued that Hamar language will be used as medium of instruction up to primary level within the Singlung Hills Council area. Full stop. The notification was dated 29th of October 2020. Full stop. In pursuance thereof, textbooks were also prepared. But for regions known to for regions unknown, the said textbooks were not accepted by the Hamar community. Full stop. It is no longer res integra that contempt lies only on willful and deliberate disregard or violation of the court's order. In the considered opinion of this court, there appears no willful or deliberate violation of the court's order. In fact, in pursuance to the said court's order, the respondent authorities had taken up various steps for compliance of the same, as was ordered. And had also issued notification to that effect. But there still appears dispute amongst the parties. However, contempt as such will not lie. Moreover, the High Court's order was in pursuance to the settlement reached between the government of Mizoram and Hamar People's Convention. Full stop. It is seen in the said settlement that representatives from both the sides were there, and it was resolved that the aforesaid agreements be followed. Full stop. It is also seen that the said memorandum of settlement has been superseded by another memorandum of settlement entered into between Government of Mizoram and Hamar People's Convention. However, with a different nomenclature. Earlier it was, I'm saying this, with a different nomenclature. That is, it was between Government of Mizoram and Hamar People's Convention, HPC, within bracket, in 1994. And the present memorandum of settlement, and in the subsequent memorandum of settlement, was between the Government of Mizoram and Hamar People's Convention, within bracket, democratic. However, the fact remains that the settlement were for the benefit of the Hamar community. It will be not out of context to mention herein. It will be not out of context to mention herein that the representatives of the Hamar community can again have a talk with the government of Mizoram for their benefit, which they have been doing since long. As such, this contempt application is closed in view of the aforesaid facts and circumstances of the case. Okay? You have been talking with the government, you got settlement, you came to court. Court had given simply whatever government said, you do it. So again, you go to government, have something.
Madam,
And see, Singlung, when they started doing with Singlung, you had not objected.
Madam, if it is not implemented,
Okay, you take whatever recourse you want. Okay? Yes? Petition is disposed of. Or contempt application is disposed of.
Madam,
Mary,
allow us-
yes?
allow us if they have not implemented to approach this, your lordship again, madam.
No, then there will be contempt again if they have not implemented. They have implemented. They have done whatever is
Medium of
required.
instruction, my lord, still not done. It is in the state of, that is our main point, madam.
No, I mean, see, I have given the reasons. You talk with the government and get a solution, well, according to me. Yes, Miss Mary, you want to say something? Okay, yes. Yes,
Regarding-
matter is over.
Regarding civil subdivision, government administration department,
Huh.
PWD subdivision, not the whole department, my lord. Health and family and home department.
What? In respect of 5.3?
Anyway, that one's, yes.
Okay, 5.3 to, it's created, so enough. We cannot go on further. You can come to the court as and when required. Okay? Yes?
Seek your lordship indulgence in mentioning part 2 hearing item number 1.
1 is fixed today, I'll take it up.
On behalf of Jamaica Security Joseph L. Clay, due to personal difficulties, he cannot attend the court. So if this matter will be taken tomorrow.
So item 1 is by Saurabh Pradhan.
My lord, I'm for the appellant.
Oh yes, you are there. And Joseph is not there, Rentley?
My lord,
He's not there.
Yes, my lord.
He's there.
No.
he's not there today.
Okay, tomorrow.
After a week, because
Otherwise, it's a criminal appeal of 23 I could have disposed of. Okay. Learned counsel for the respondent. Oh, who is no one is there. Yes, yes. Learned counsel for the respondent. Prayer is made on behalf of the learned counsel of the respondent. That is the amicus curiae, to take up the matter on a later date, which is not objected to by learned counsel for the appellant. Accordingly, list this matter on 10th or 11th of August. Okay? Or it will be too late. 4th of August. Okay? 2026. Yes. Okay.
has been damaged. The authorities should be directed to acquire the lands if they are going to continue using the lands or pay compensation for damages caused to the land. Mrs. Linda L. Fumble, the learned government advocate, submits that as per the affidavit filed by the state government, the claim of the petitioner cannot be ascertained unless a verification of the petitioner's land is undertaken. Mr. Ali Hussain, the learned counsel for the respondent number 2, submits that he has no objection to the prayer made by the petitioner's counsel. However, at the time of the verification, the NF Railway should be represented in the verification team. In view of the consent of the parties, this court is of the view that the verification team should be constituted. Accordingly, the Secretary to the Government of Mizoram Land Revenue and Settlement Department shall constitute a verification team consisting of the district collector, deputy commissioner, Kolasip, or his representatives, the deputy chief engineer, construction, NF Railway, Silchar, Qatar, Assam, or his representatives, and the petitioner who shall verify the lands of the petitioner within a period of 1 month from the date of receipt of a copy of a copy of this order. The verification team consisting of the above persons shall verify whether the lands of the petitioner have been used by the respondent number 2 for constructing a road. If the answer is to the above is found to be in the affirmative, the respondent number 2 shall immediately take a decision within 2 weeks from the date of the site verification as to whether they want to permanently acquire the lands. If the answer is in affirmative, they shall make a requisition to the respondents number 1 and 3 for acquisition of the lands. Thereafter, award shall be made as per the right to fair compensation and transparency.
One second. The verification been used. The respondent otherwise 2 is where? By the side of the land of petitioner? No.
The road constructed is made by the respondent number 2, my lord.
To reach to his house or what?
No, the road itself.
He is who? Not a private respondent?
No, railway. my
Oh,
lord.
railways.
Railway siding, railway station.
Achha.
So, if I may continue, my lord?
1 second. They shall make a requisition. Yes. Thereafter, award shall be made.
Thereafter, award shall be made as per the right to fair compensation and transparency in Land Acquisition, Rehabilitation and Resettlement Act 2013 within a further period of 2 months. In the event the respondent number 2 is not willing to acquire the lands, the respondent number 2 shall stop using the petitioner's lands immediately. In the event the respondent number 1 shall verify and assess the damage caused to the petitioner's land within a month from the decision taken by the respondent number 2, and the amount so computed by the respondent number 1 shall be paid by the respondent number 2 to the petitioner within a further period of 1 month from the date of the assessment made by the district collector cum deputy commissioner concerned. Thereafter, my lord, the certified true copy of the order was given to the respective respondents on September 2020. And thereafter, notification in pursuance to the judgment and order dated 19/3/2020, notification at page number 17.
So, verification team constituted.
Yes, verification team was constituted by the respondent number 3. So in here, in pursuance to the Gauhati High Court Aizawl bench dated 19 March 2020 in the case of WPC 148 of 2019 Shri F. Lalhungliana versus SOM and 2 others, verification team is hereby constituted to verify the lands of F. Lalhungliana at Bairabi, Kolasip district covered by periodic pata number so-and-so 58 of 2024, where is damage and construction of approach road by NF Railway. The verification team shall comprise of the following: deputy commissioner, who is the respondent number 1, or his representative, deputy chief engineer, construction, NF Railway, Silchar, Assam, or his representative, that is the respondent number 2, F. Lalhungliana, Bongkwan South, Aizawl, who is the petitioner in the WPC 148. Accordingly, my lord, the state respondent called for spot verification on 4 occasions. that I have not annexed in my submission, but the state respondents, the contemnors have already submitted in the affidavit. So accordingly, spot verification was called 4 times. And the first spot verification was called on, excuse me,
Mr. Medhi, you can sit. You can have your seat. Yes.
11/12, 2020, that was the first spot verification. I hope the contemnors will clarify this at a later. And verification report was submitted on 16/12, 2020. In this spot verification, all the parties were present. And in the second spot verification, the petitioner I and the respondent number 2, the NF Railway, were not present. So verification could not be completed.
So the first verification was completed and a report is submitted.
Yes, my lord. But then again, clarification was sought again. That's
Report
why.
dated?
Report dated 16/12/2020. That was the first verification report.
But then there are some disputes.
Yes. So and on 5/2/2021. The next spot
5/2/21.
Yes, second spot verification was ordered. However, since the petitioner I, along with the NF Railway, the respondent number 2, could not attend, the verification could not be concluded. And the third spot verification was again called on 23rd March 2021. At this time, undated verification was submitted. Verification report was submitted. The NF Railway, who is the respondent number 2, did not attend.
Oh. In the verification.
Yes. So that could not conclude the verification. However, on the last verification, which was done on 15/9/2021, verification report was submitted on 29/2021. All parties appeared. Final spot verification was also submitted on that date.
A report is there in the petition?
Yes, the report was submitted by the respondent, by the contemnors, my lord. At page number 27, the show cause reply submitted by the respondent number 1. Page number 27, annexure number 7.
There is no running page here. 27.
Yes, my lord.
Yes.
Show cause reply by the respondent number 1.
This is by 1.
Yes, my lord. Show
Yes.
cause.
Respond number 3. Page number 27 is the part of the affidavit filed by respondent number 3.
Mine is respondent number 1, my lord.
You mean to say the attendance sheet?
No, in my copy, page number 27 is annexure number 7, spot verification report. 31.
31.
Yes. Or respondent number 1.
31 is the statement for assessment. No, what affidavit you are talking of?
Respondent number 1, show cause reply by respondent number 1.
Respondent number 1. Respondent number 5. Yes, I've got one. What is the page you said?
Page 27, my lord.
Page 27 of their affidavit.
Yes, my lord.
27. Mm. 27, yes. Spot verification report.
The final spot verification, what I would like to submit is that 2 spot verifications report were submitted. Number 1 is at page number 27, annexure number 7. If I may read the portion, my lord.
This is the last spot verification.
Yes, my lord. So,
Date? This is actually fifth. Fifth or what?
No, my lord. This is the fourth verification.
First verification was on 5/2/2021.
No, first verification was 11/12/2020.
11/12/2020.
Yes. And the second is 5/2/2021.
Acha, the first what happened?
First, all appeared, verification report was submitted, but then they could not conclude due to some irregularities. So they prayed for another spot
Report
verification.
submitted, but irregularities were found.
Yes, submissions were made by all the parties regarding their claims. So they wanted to make another.
So second was on 5/2/21.
Yes, my lord.
Where you and railway were not present.
Yes, my lord.
Then 21/3/21.
No,
Third.
23/3/21.
23/3.
Yes, my lord.
23/3/21, where R2 was not there.
Yes, my lord.
So then 15/9/21.
Yes, my lord. That was the final, the fourth and final time.
Acha, the present one is 15/9/21.
Yes, 59.
Report is 29/21.
Yes, 29/21.
Okay.
The first report submitted is at page 27. If I may read from paragraph number 1, my lord. The land was indeed damaged by NF Railways by constructing road. The land of the road constructed within Lal Hungliana's land was measured to be 960 meter with the width 20 meter. Paragraph number 2. Periodic pata number so and so 59 of 2005 is under the name of Lal Hungliana's wife Satsami, and damage is measured as 60 by 20 meters equals to 1200 square meters. Number 3. Periodic pata number so and so 58 of 2005 is under the name of Lal Hungliana. Damage is measured at 900 by 20 meters, which is equal to 18,000 square meters.
This is same land owned by the same person.
Yes.
One is by wife and one is by husband.
Initially, my lord, here I would like to clarify that at the time of filing my writ petition, I had bought the land. Sale deed was submitted at the time of filing the WPC. So all the lands were not in my name, it was in somebody else's name, the previous owner's names. So during the pendency of this whole thing, the pass came out in my name and my wife's name. So mine was under 58 of 2005 and my wife was 59 of 2005.
Okay.
So thereafter, my lord, at page number 36A of the same show cause
So
reply.
it said that there has been some damage.
Yes, my lord.
And the NF Railway has constructed the land.
Yes, my lord.
And the damage is measured at so and so square feet.
Yes, my lord.
Square meter.
Yes, my lord.
And then what about 4, 5, and 6 not reported?
No, my lord. So thereafter, joint verification, another joint verification report with respect to the 15/9 was also submitted with regards to the assessment, my lord. So which is at page number 36A. Joint verification report.
36.
36A.
36A.
Sorry, 30A.
38.
Yes.
Okay.
30.
30.
30A.
Oh, 30A.
Yes, it's a type copy.
Okay. 3030. Yes.
If I may read, my lord.
What is this? Joint
Yes. with
Not the same report.
Not the same report, but with respect to the same verification.
2 reports were submitted.
Yes, my lord.
Acha, 2 reports.
That report depends upon the subsequent.
It's not, my lord. Two reports.
Joint verification report and
Yes.
the sub-spot verification report.
One was the clarification, one was the main spot verification, and the other one was the joint verification report clarifying the events that happened on that day. So in pursuant, if I may read, my lord, in
Joint.
pursuant to letters so and so.
Acha, that earlier report was not signed by the verification team. It is Deputy Commissioner.
It was signed by the representative of the, yes.
Deputy Commissioner. Okay,
So,
joint verification.
Yes, from the joint verification, it can be seen that all the parties were present at the time of joint verification. And as per the direction of Land Revenue and Settlement Letter number so and so, Assessment of damage was carried out. The length of damaged land as measured by the surveyor was 960 meter, while the breadth was 20 meter. Two lands were measured, periodic pata number 58 of 2005 and periodic pata number 59 of 2005. P pata number 59 of 2005 damage measured equals to 60 by 20 equals to 1200 square meter. Number 2, P pata number 58 of 2005 damage measured 900 by 20 equals to 18,000 square meter. The representative of NF Railway refused to sign in the assessment sheet because he claimed that the assessment was not mentioned in the notice and that he cannot take decision by himself on spot.
Okay.
So thereafter, my lord, at page number 32 of the same show cause reply,
32.
yes, my lord, annexion number 8.
Yes, surveyor's verification.
Yes, the respondent number 1, the respondent number 3 submitted to the respondent number 1 the surveyor's verification report along with the assessment for compensation, my lord. So with reference to the subject mentioned above, I have the honor to forward herewith surveyor's report on spot verification of P pata number 58 and 59 of 2005, both owned by F. Lal Hungliana, along with the assessment of land value amounting to 51,64,800 rupees, only for favor of your kind information and necessary action.
This assessment of land is in respect of the
Spot verification of my lands.
not the entire land, it is only that portion
Yes,
which
only
is
for that
acquired.
portion, yes. So which we can see from page number 34, my lord. This is the assessment sheet and the compensation calculated by the state respondents. my lord.
34, okay.
34.
Okay.
Of the same-
59,
Yes,
property
59 of
damage.
2005, property damage 60 by 20. And the amount so calculated is 3,22,800. The vernacular language has not been translated, so if I may, my lord, it is written as since the railway, the land has been, the land rate has been calculated at 25%, since this portion is still under the railway's construction. So the land,
25% of the land.
yes, no, 25% rate, the land value.
Acha.
So during this time, the construction of the railway line has already been completed.
No, you mean to say that the damaged part was calculated. I mean,
Yes, my lord.
And it was found that 3,22,800 is the loss
Is the amount incurred for the damage.
incurred for the damage.
Yes,
So
for-
what about this 25%? I didn't get it. 25% per square feet. So it comes down to 3,22,000. Right.
Yes.
If I may, there's a table there. The name, forest name is there, past permit property damage, stage area, volume, and the rate is mentioned over there. It is 25.
25. Okay.
Yes, 25 square feet.
25 rupees per square feet.
Up 25 rupees per square feet. Now what is this later 25%?
A whole land.
This one.
I believe in my humble opinion, Lordship, since I don't have even the vernacular translation, I believe in my humble opinion, it should be read as that
25 per square feet.
it should be calculated as 25%, and at that point of time, all those compensation was calculated as per this rate, 25%.
25% of what?
25% of Lordship.
Acha, anyway, we know that it is 25 rupees per square feet and it comes to 3,22,000.
Yes.
Okay, then
And at page number 35, my other periodic pata, 58 of 2005.
that is 58.
Yes,
okay.
my lord. The previous one was 59, and now it's 58.
For 48 lakhs 42,000.
Yes, 48 lakhs 42,000. So since the state respondents have done their part in constituting the verification team and for assessing the damage and the amount of compensation to be awarded to us, it is now upon the respondent number 6, who is the impleaded person, to clarify whether they are going to acquire my lands or they are going to pay mere compensation for that, which the respondent number 6 have failed to do so till date. So we have filed the instant contempt petition number 8 of 2022 against the respondents number 6. So as per the judgment in order dated 19/3/2020, it has clearly, the judgment clearly stated that if the answer to the above is found to be affirmative, the respondent number 2, now respondent number 6, shall immediately take decision within 2 weeks from the date of site verifications as to whether...
Wait, where was the order? Which page?
At page number 14 of my petition, my lord.
Wait.
Of my
The contempt petition.
Yes.
Page 14. Yes, yes.
So
So first of all, they will do a spot verification. They did it.
Yes, my lord.
They filed a report.
Yes, my lord.
Secretary Land Revenue shall call the verification team. Okay, this is done. Shall verify whether the lands have been used for constructing. If the answer is in the affirmative, take a decision, permanently acquire. So this decision they have not taken.
Yes, either they permanently acquire or they pay compensation, my lord, which is at the second last paragraph, my lord. So this has to be done by the now respondent number 6 to make that decision. While the state respondents have already complied with the judgment and order, it is upon the respondent number 6 to either acquire or to pay the compensation, my lord.
Respondent number 2 is now 6.
Yes, my lord. Yes, this is the new incumbent.
So there are two alternatives given. If you want to acquire, then you do it through respondent number 1 and 3.
Yes.
They will do the needful. And if you do not acquire, then you have to give the damages.
Yes, my lord.
And damages has been calculated
Yes, my lord.
as per the chart that you have shown.
Yes, my lord.
Okay.
So with respect to the state respondents, they have already done.
Acha, so this is your case.
Yes, my lord, that is my case.
Affidavits are exchanged, right?
Yes, my lord, all
You have
received.
shown from that affidavit only.
Yes.
So many affidavits are there. Okay. This is your case. I can come to
Yes, my
Mr.
lord.
Medhi now.
Yes, my lord.
Before that, these two order, the review order,
Review order.
yes, madam.
Review has been filed against that order.
Yes, against the order.
Against the order of this.
Order of declared order, madam.
19 March 2020.
Yes, madam. That was dismissed, madam.
So,
And before that, your lordship made.
so review dismiss. So what is the purpose of? Huh?
Yes, yes, there is purpose, madam. Madam, before that, your lordship may produce the contempt, and there is an order in the date 17/6/2025 in contempt case, madam.
The content, the order against which violation?
No, madam, there is order of the contempt proceeding, madam, 17/6/2025.
Where is that?
It is in contempt case, madam.
Oh, acha, this case.
Yes, contempt
17/6.
2025.
Wait. Five. 25 or 26?
17/6/2025.
Yes.
It was by Honorable Justice.
Marley.
Yes, madam.
Yes.
Second paragraph I am reading, madam. The council, learned council for the respondent 5 submitted the court in order that 19/3/2020 passed in WBC number 148/2019 has not specified this periodic passes which are to be verified by the verification team, and submitted that since the periodic pass number 59/2005 is not in the name of the petitioner, and they would like to file a review petition before the concerned bench. Hence, he therefore paid time to file review petition before the concerned bench. The learned council further submitted no objection was already been obtained from the deputy commissioner on 6th February 2015 and would like to place the before the concerned bench. Learned council for the petition, in all fairness, submit that the periodic patta number 59 is the name of the wife of the petitioner and not name of the petitioner, and C, however, submitted the learned court in order that 19/3/2020 passed WPMC number so and so has mentioned that periodic pattas which to be verified. This court, considering the submission made by learned counsel for the parties, it finds appropriate if respondent 5 is given liberty to file review petition in the interest of justice. Accordingly, contempt petition is adjourned. This same order was passed in my WPC also. There is one WPC matter that was disposed of. Because contempt petition is here, my lord, so this honorable court.
So, okay, you have filed a review petition, it is dismissed then?
Yes, my lord. This now your lordship may take this order of the review petition 257 of 2025.
Yes. Which paragraph?
Yes, my lord. From paragraph 2, my lord, the review petition has spread for review of the order of order the 19/2020 passed in WPC number 148 in 2019. Here, the respondent were directed to consider verification team to verify as to whether two plot of land of the petitioner here should be acquired under right to fair compensation act, transparency, so and so. He should or should be paid damage for the damage caused to his land on account of the railways having damaged land of the petitioner hearing. Learned counsel for a review petition submit that this court in impugned order that 19/3/2000 had directed that two plots of land covered by periodic patta number 501-801 /1058 2025 and 59 of so and so should be verified in terms of the direction passed by above. However, it has been been ascertained after being that while periodic patta number so and so being belong to the petitioner and other land covered periodic patta number belong to wife of the petitioner, he accordingly submitted that there should be a review of the order dated 19/3/2020 passed in WPC number 148 as much as the petitioner in WPC are not the owner of the board of lands. This court outside finds that direction passed by order dated 19/3/2020 in WPC number had been complied with, inasmuch as verification team has been constituted and verification report made. Thereafter, pursuant to the verification report, district collector Kulasip had made an assessment and
okay, I've read it. Okay, fine. You just said that
yes,
since it is follows and nothing is required to be reviewed.
Yeah, my lord, my contention is that paragraph number 6 also, considering fact and direction passed by this court, impugned order dated 19/3/2025, the petition has already been complied with. As per this court, my lord, order is already complied with, the observation, my lord. Now, there is nothing to be reviewed. In view of the petitioner is not happy with the verification report and content thereof, same should be put to challenge by your appropriate petition before the appropriate forum. If the challenge is paid, there is no bar for a review petition to approach the higher forum for forum with his grievances. However, no ground for review made and review petition has been dismissed.
Then?
My submission is that as per this order, my lord, this order is already complied with, my lord.
The order dated 19/3/2020 is complied with.
Yes, paragraph
How
6.
can you say this is a compliance only with regard to spot verification?
My lord, paragraph 6, my lord, on considering facts and circumstances, the direction passed by this court, the impugned order 19/3/2020 passed in WPC has already been complied with. Nothing is to be reviewed. So
I don't know why you don't understand. This is on spot verification only.
My lord, thereafter, I am coming, my lord.
There is nothing. Only you have to answer whether this thing was done, whether you have applied to respondent number 1 and 3 for acquisition,
My lord, no,
and if not acquisition, then whether damages.
No, my lord. We have challenged as per this order, my lord, subsequently in WPC number 1 and 2, my lord. There is 2 order, my lord, we have challenged, my lord.
Where? Which WPC? Be clear on what you say.
It is there, my lord. It is there.
What date?
It is-
In the writ petition, this one?
Yes, my lord.
So what is the, be on the contempt application first, then we will go to writ petition.
Yes, my lord. So this in contempt petition one, we then dismiss that the observation is that if we are aggrieved, my lord, with the direction of, with the, whatever it is stated that, a paragraph on 6, my lord, 6, my lord,
And how many times he'll read the same thing again?
My lord, just a minute, my lord. If review petition is not happy with the verification report and contents there, same should be put in challenge by appropriate petition before the appropriate forum. So we have challenged in this same in the W petition 1 and 2, my lord.
So you have challenged the verification report?
Verification report, my lord. Verification report, my lord. So it is before, so this 2 petition, contempt petition as well as petition was taken along with, my lord. So, my lord, before I want to submit this my additional affidavit. What is there, my lord?
Where is the additional affidavit?
Yes, my lord. It was additional affidavit. It was, my lord. It was 5 February, my lord. February 2025, my lord. 24 February 2025. 24 February.
See, what the review court did is what?
My lord, what happened, my lord?
Listen to me first. What did the review court do? You have challenged the order 19/3/2020
Yes.
on the ground that ownership of one of the land was not there.
My lord.
Your contention, listen to my question first.
Yes, yes.
Ownership was not there in respect of one of the land, and you said that order is bad. According to you, the order was bad. That is why you have filed a review petition. But then the court said that you have taken recourse to the directions given therein, so there is nothing to be reviewed.
So,
And as far as the other land, it is of the wives and it is of the husbands.
So we have challenged the report itself, report subsequent in the WBC in 112 here tag with mail. So it was the observation.
No, first of all, whether you have decided to acquire
No,
or
my
not.
lord, no, lordship will bear with me. My lord, in their writ petition, my lord, land was, my lord, they buy it and it was sold to them in 2018, my lord. 2018, it was their land. From 2019, they filed a representation before a concerned deputy commissioner. The land was damaged by the railway. In said deputy commissioner, it was when they claimed compensation, the deputy commissioner says, no, you go to court. Court will give direction.
No, we are not concerned with all this. Now we are concerned with post contempt.
But in 2015 itself, there's a road. Road was allowed to develop. So there's no objection certificate. So that verification report in my friend.
No, you cannot just go on with the past occurrences.
No, lordship.
This has been settled. Writ petition is over.
Yes, my lord. So direction of the writ petition is not completely followed, my lord. So it is page 28 of my my lord. Page 28 of my additional affidavit, my lord.
Where? Filed in contempt?
Yes, my lord.
What is the date?
My lord, I already told it was filed on 24 February 2025.
24 February 25.
My friend already read my lord, this report, my lord. 16/12/2020, my lord. 16/12.
When was it filed, your additional affidavit?
It was filed, my lord, on 24 February 2025.
24 February 25? There are no such 24 February. 17 May 22, then 22.
Additional affidavit.
This is when? 17 May 22. Hmm? 24. Where is 25 affidavit? You take out and give it to me. Doesn't? Court master, give him. He will take out the affidavit. I'm not able to. Give him the file. Which affidavit you are talking of? You've got it?
Yes.
Yes.
My friend also put this on the page, my lord, in my.
Which page?
Page
You're
20, page 28. my lord.
28.
Revision report so and so, 16 December 2020.
16 December.
Yes, ma'am. Already it was shown.
16 December 2020 is
Already shown by my lord.
16 December 2020. Okay, there was some irregularity. So
So
next.
I'm coming, my lord. This my friend not read everything, my lord. The argument of argument for this petitioner. Railway has constructed road.
Which 8? A, yes.
Page 28. There is A and B. Argument of some this is the petitioner who F Lal this one he railway has constructed road through his patta land number so and so and so and so. Thereby damage his land by cause damage by dumping soil. Copy of patta enclosed. He has not been given paid compensation so and so and so total so and so. Argument of the railway representative. Railway has started work repairing the existing road after obtaining no objection certificate from DC scholarship dated 6/2/2015. A copy enclosed. So this land was this petition itself reflected there that the land was it was sold to them in 2018, my lord. So before 2015, this no objection certificate was there. The railway developed the road. The claim of the damage dumping fact is in fact construct material improved the said road. It has been it has been 6 years since the work started. No objection has been raised within this period. Observation during the verification. The approach road passing through the land of so and so currently utilized by railway existing on the date of verification and currently being developed by so and so. So and so claim that no motorable and so is land before the railway started work. On the other hand, railway representative Sector Prakash claimed that they have not constructed any new road and they are not they are only developing existing road. The question of whether the road existing before the railway obtained NOC from it needs to be clarified with the VCP of Bhairavi. Where no option was taken by VCP Bhairavi from the land owner concerned before using NOC for developing of existing road needs to be classified. During the verification, representative settlement of it did not turn up. Hence, the actual damage claimed by so and so could not be established. So, in my affidavit, this turn.
This first verification report has no meaning actually.
No, so there
could not be ascertained.
Yes, so on the basis, my lord, whether there is the NOC was there, whether the existing road was there, what it was developed. And the thing is that the NOC was given 2015, and it was land was sold to them in 2018. So before that, it was developed. So this page 40 lordship matter.
14 of that affidavit?
Yes.
It's not legible.
I am reading. This is to state that the district administration scholarship Mizoram does not have any objection to the NF railway for developing and repairing the existing road from Rajdarali to Bailung River.
Where are you reading? Page 14?
40.
Yes, no objection by district administration.
Yes, my lord. This is to state that the district administration scholarship district Mizoram does not have any objection to the northeast frontier railway for developing and repairing the existing work from so and so to river up to NH 154. Northeast frontier railway will utilize the said road, but ownership will be remain with Bhairavi Village Council. A supplementary no objection certificate from Bhairavi is enclosed to substantiate the said documents. So next page is, my lord, is
Ownership will remain with the council.
yes, my lord. Next
Supplementary non-objection certificate from council is enclosed.
Next page is 41. Actually, I thought the same page. So it was, my lord, written. The certificate the present is to the NF Railway for developing and repairing the constructing road from so and so to so and so. The NF Railway will be utilize the said road, and ownership will remain with the Bhoiravi PC. So this was my 2015 itself. Of this road was given by the village council. My lord. Subsequently, 2018, this land was sold to the petitioner, and then 2019, my lord, this for my satisfaction, I'm placing before your honor, your lordship, my lord. This, my lord, is page 23, my lord, is the sale deed, my lord. It is 23, my lord, page 23.
23 of this affidavit?
Yes, my lord. It is in Mizo, my lord, my language, my lord. Page 24 is the translation, my lord. I am selling my land located at Bhairavi covered so and so, so and so, so and so. These are the plot. To the repetition name, my lord. This one 29 10 2018, my lord. So today it was, my lord. And my lord.
So it was sold in which year?
2018, my lord.
2018.
And the NOC was given by the village council in 2015 itself, my lord. So road was, in fact, it was developed, my lord. It is not denied, my lord. So the thing is that, my lord, I want to place one document, my lord, for my satisfaction. Lordship will pass order accordingly, my lord. My lord, it is, if lordship may take the read petition, my lord, my read petition, my lord. Lordship is.
Yes, read petition, what you want to show?
This, my lordship may turn page 44, my lord.
44?
Yes, my lord.
Yes.
It is to the Deputy Commissioner, my lord, Scholarship District. Compensation for damage caused upon my land by railway by constructing approach road. I request you to kindly consider my representation.
He is the owner of the land, Langlung Giliana?
My lord, yes, my lord.
Husband, petitioner.
Yes, my lord. The plot of land is belongs to his wife, my lord. He never disclosed in the repetition. He, according to him, both land belongs to him. So it was never disclosed. Subsequently, it was in report disclosed. This plot of land is so and so plot of land. So it was separate assessment here. So here, as mentioned above, my land located at Bhairavi under pass number. Lordship may be noted, my lord. This only pass number 501-801.
No, you're reading this letter, right?
Yes, ma'am. Yes, my lord. It is his representation, DC, my lord.
Compensation for damages. Yes.
Only this pass was mentioned, my lord.
58.
Yes, my lord. Has been damaged by the railway company due to construction of approach road within my land for transportation of their materials. The damage caused by land is roughly 1 kilometer, and also irregular dumping earth has been destroyed the existing pond process. Fish good terrain and of the land has all be covered by earth. Therefore, request to kindly look into a matter to take necessary step for verify and measure extent of damage cost of my land for the revenue land collector, so that I may be paid compensation. It was, my lord, 15/9/2019. Land was sold to them is 29/10/2018, my lord. My lord, thereafter, my lord, they approached, my lord. And here also there says, my lord, the existing pond, proposed fish pond, and good, all these things destroyed, my lord. But verification report, my lord, never disclosed all these things, my lord. Thereafter, my lord, DC scholarship, my lord, page is vernacular is page 45, transition is, my lord, page 46, my lord. Is page 46. Lordship, got it? The complaint regarding compensation claimed by you for damage caused upon the land by the railway cannot be settled from the office. We advise you to take up the matter before the redressal of the grievances, my lord. So thereafter, my lord, my lord, on 19, my lord, this 2015 itself, the NOC was given to us, my lord. We never denied that we developed, my lord, no question of this. But this was done, my lord. And this was, my lord, subsequently the court also directed to verify, my lord. Court was not that this already it was done, my lord. The court was directed to verify everything. So we are the party, my lord. We are the party. So we object, my lord. We object in initial report, my lord. It is based, it is, my lord, dated 16/12/2020, my lord. In my affidavit, my lord. So that, my lord, is in 16/12/2020. The reports, whatever the verification report speaks, my lord, the observation of during verification, the approach road passing through so and so utilized by railway, existing on the date of verification and currently being approached by the actual utilized, who claim that the no motorable road accessible land before the railway started work. On the other hand, the railway.
Acha, what do you say about the fourth verification report?
My lord, this so, my lord, fourth verification reports, my lord, it is, my lord, I have also enclosed, my lord. Fourth verification report, my lord, this, my lord, PS, my lord, 39, my lord.
39 or what? You see it from the contempt petition?
Yes, my affidavit, my lord. Same, my lord. This is, my lord, dated 15/9/2021. In my affidavit, my lord.
Page?
39, my lord.
Yes. 39.
Yes, my lord.
Huh.
My lord, before that, my lord, before going to the verification report, my lord, lordship, page 36 required, my lord. This is the joint verification notice, my lord. Page 36.
Yes.
In pursuance to the letter dated 3/8/2021, Government of Mizoram Land Revenue Register, the reconduct the spot verification in respect of periodic patta number 501
Okay, 58 and 59.
59 in the owned by so and so is hereby rescheduled on 15 September 2021. Following spot verification team requested to reconduct spot verification and report themselves on the office of sub deputy commissioner Bhairavi on the above fixed date and time. All the relevant documents pertaining to said land be produced by the owner, landowner. So these are.
So he is a serial number 4. Okay. Then
yes,
your representative was also there.
Yes, my lord.
Then?
My lord, and then page 39. Joint verification report. Pursuant to letter dated so and so verification was held at a land named by so and so Bhairavi Scholarship on 15 September 2021 at 11 a.m. During the verification, following people are present. These are present. As per direction of the land revenue so and so, the damage was carried out. Assessment of the damage was carried out. Length of damage, but there is no whisper, my lord, in that the dated 18 August 2021, page 36, my lord, for assessment of the damage, my lord. It was only to the reconduct the spot verification and the report themselves on the office of the so and so. So they, my lord, they says as per direction of land so and so, damage was carried out. The length of damage of
Where are you reading?
39, page 39.
Yes. As per direction of the Land Revenue Department, assessment of damage was carried out. The length of damaged land is so and so. And your representative refused to sign because the concept of, because the subject of assessment was not mentioned in the notice.
And therefore, my note, my lord. The matter is already submitted to PC Scholarship during this going for verification, verification December 2020. Therefore, I am not agree with the findings of this so and so, my lord. So it was, my lord, the December 20 minutes, my lord.
This is by the landowner. It's written landowner, what?
No, it was by, my lord, the railway, my lord. Page 38, your lordship may turn, my lord.
39?
Yes,
Huh?
my lord.
38.
38, my lord, 38. Last. The matter is already, it was, my lord, signed by the Saitya Prakash, my lord.
Okay. So?
So it was already decided, already, my lord, that was, my lord, whatever this 16/12/2020, my lord, regarding the NOC and the other part, my lord, the observation, it was, my lord, as per that report, my lord, it is written like this, my lord, the question of whether road existed before railway obtained NOC from the DC scholarship needs to be clarified on the.
So, wait. I mean, here directions were given in this way that we have seen already.
Yes.
In order dated 19th of March 2020. And now you are saying that verification you are not happy with and you don't agree with the spot verification number 4.
My lord, this we have already stated in first verification report, my lord.
So what is your stand now? Whether you will acquire that land, whether you require that.
My lord, what happened, my lord? There is a road already there, my lord. We developed the road. Not only railway, the other people also using that road, my lord. My lord, maybe, my lord, I don't know, my lord, the client of my friend, my lord, they purchased the land, my lord, after developing the railway road, my lord. So they approached, if, my lord, damage is there, it was decided by the civil court, my lord. And particular point of time, my lord. This verification report, my lord, if verification report we comply, we decide, my lord, then 16/12/2020, my lord, it says, my lord, there is no objection on VCB Bhairavi. That has to be considered. But this was.
You should have raised this during the disposal of the writ petition.
Yes, my lord. So writ petition was not, my lord. It was subsequently, my lord. This verification report is subsequently in persons to order the High Honorable High Court.
Yes, no.
So our contention was, my lord.
You should have said that these plots of land were not theirs when the road was first constructed. And thereafter the railways had taken it on the no objection certificate given by.
So we filed a writ petition, my lord, the 112, my lord. That's why.
But this is after your order dated 19th of March 2020.
So even with the report number, joint report.
During the writ proceedings, railways were made a party.
Yes, my
Yes,
lord, they
ma'am.
were represented.
No,
and
we
the
are
submission
not
was that they have
not
no
objecting
objection.
the order of the High Honorable Court, my lord. In Honorable Court also, my lord, it was his claim that all those.
They were respondent number 2.
Yes, my lord.
So respondent number 2 had no objection to the prayer made by the petitioner's counsel.
My lord, prayer, my lord, only to verify, my lord. What prayer? Prayer was, my lord. Prayer was, my lord, this only, my lord, to verify, my lord. Prayer
No,
was-
after that also it's there. After verification, if he is find that so and so and that has not been done.
My lord.
My lord, if I may have your kind attention at page number 29 of the writ petition, my lord.
Contempt petition.
His writ petition.
Writ
my lord.
petition, 29.
Yes, my lord. That is my prayer portion in the writ petition number 148 of 2019, my lord. In the premises aforesaid, it is most humbly prayed that your lordships may graciously be pleased to admit this petition and issue notice upon the respondents to show cause as to why the respondents should not be directed to verify the claim of the bereaved petitioner and pay compensation found due to the petitioner for the acquisition of his land and damages caused upon his private land by constructing an approach road within his lands and upon cause or causes shown and after hearing the parties and upon perusal of the records.
This is what? This is the prayer in a writ where the
Yes.
order was passed.
Yes, my lord.
By
This is my
Justice Michael.
prayer. Yes, my lord. And I have prayed for, and I have also prayed for the compensation or either damage, my lord.
No, what I can deduce is that those lands must be empty without any boundary walls, right? And then people were using that as a land. Railways have also started using that as a land. And after that, it is the land was sold to these petitioners and his wife. Right. It was sold when he had shown me a
Yes, 2018.
2018.
Yes, my
It
lord.
was sold.
Yes, my lord.
And thereafter, the land passes covered that land where the road was going on.
Yes, my lord.
And so now they have claimed the compensation.
Yes,
Now the railways have to decide whether they require that land or not.
Yes,
My lord, only thing is, my lord, this land was.
But the fact remains you have damaged the portion of land.
My lord, this, it was, my lord, damage was not, it was not reflected in the report, my lord. Report, lordship made, this, before that I am coming, my lord, no objection, certain, this speaks, my lord. This supplemental no objection certificate from village Bhairavi council is enclosed. My lord, it was the ownership of the village council, my lord.
No, initially the entire land was under the village council. Thereafter the passes.
So, my lord, we obtained the NOC from the district collector as well as, my lord, the village council, my lord. Village council is allowed. So we develop, my lord. So this part. Then thereafter, my another submission before your lordship is there. So how they assess the land? How they assess the land? The assessment lordship may turn how they assess the land.
But then those facts you did not place it before the writ court.
My lord, what about the only the direction to be verified and then thereafter assessment, my lord? That will come thereafter, my lord. So we filed the writ petition before the honorable court, my lord. So initially,
Writ petition was after this contempt order.
I
After this
understand, my
order.
lord, but which was contempt in the contempt petition, my lord, that was, my lord, only to verify and assessment, my lord. Now how the district collector office, my lord, the assessed, my lord. Lordship, that has to be looked into, my lord.
But now, okay, you had taken no objection and all that. Initially, it was not their land; it was under the village council. And then, what?
My lord, if I may be allowed to make some clarifications on that, page number 13 of the affidavit filed by the instant respondent, my lord.
In the contempt.
Yes, my lord, in the
Page number?
Page number 13.
In 2025 affidavit.
Yes, my lord. No, 8 of 2022. Yes, 24 to 2025 affidavit.
Huh.
So at page number 13, annexure A.
13.
Yes, 13.
Yes.
Page
It
number
is not readable.
Yes, at 15 is the type out copy.
15.
Yes.
Okay.
So before this, I would like to state that as per the submissions of my learned friend, the no objection was obtained on 2015. So these passes have already been there. The pass number is 58 of 2005. And
Yes.
then 59 of 2005 at page number 20.
So 50 of 2005.
58 and 59 of 2005.
58 of 2005 was there when?
At 2005, my lord, before the construction of the road.
So 4/2 of 2005.
So these are the lands that I have purchased.
In the year 2005? No.
No.
18.
These passes were already there. My learned friend said that no, the passes were in the possession of the VC Bhairavi. That was wrong, my lord. These passes,
passes
these lands,
were- this 58
these lands
pass-
were already issued to some other person.
Zorem Siama.
Yes, in the year 2005.
So
these
Zorem
lands-
Siama sold the land to the present petitioner.
Yes, my lord, to me.
Where is the selling you had shown 2000?
Yes, at page number 24, which my learned friend has also annexed. Page 24 is the sale deed. I am selling my land located at Bairabi covered under periodic pata with respect to mine is number 2 and 3, my lord.
But then no, here the seller's name is different.
Yes, number 2, periodic pata number 59 of 2005 is that Klang Ming Thanga. So he is the
Charming
father.
Liana.
Klang
58
Ming
is?
Thanga.
58 is Zorem Siama.
Yes, Zorem Siama is the son of Klang Ming Thanga.
Zorem Siama is the son of Chong Bling Liana.
Yes, Klang Ming.
No, father's name is
Yes.
Lang Ling.
Oh my God. Klang Ming Thanga.
No, CT.
No, it's, they have write it wrongly, my lord. At page number 13, C full stop, TLANG HMING THANGA.
Where is his name in page 24? Oh, acha, this one?
Yes.
Seller.
Yes, the seller. is the
TLANGH Aming Thanga. Okay, yes.
Yes.
So he is the seller here.
Yes. So the submissions made by my learned friend stating that these lands did not belong to anyone in the time during the time when no objection was obtained is false, and that cannot be raised at this instant stage. But then I have to clarify it again. The land have already belonged to somebody else's from whom I have purchased those lands. And my learned friend also state that I have not disclosed any of that 58 and 59 in the writ petition, whereas the same documents that he have submitted before this court is the same documents that I have submitted in the writ petition. So that was my same annexure. And at page number 40, my lord, page number 40, no objection certificate of the same affidavit filed by the respondent, my lord.
Yes.
Yes, no objection certificate was issued by the deputy commissioner. No objection cannot be justly issued by the deputy commissioner without no objection from the landowners themselves. This may have been issued in 2005, but where are the no objections from the landowners? No objection from the landowners were obtained. And page number 41, which my learned friend has also referred to.
Ownership will remain with village council.
Yes.
That time they did not know that ownership was with some persons.
No, this was in 2015 again. So in 2005, the previous landowners have already owned the land. So they have to obtain no objection. If I may also have your kind attention to page number 29.
Of the same affidavit?
Yes, my lord. Of the same affidavit, paragraph number 3. If I may read. Whether no objection was taken by VCP Bairabi from landowners. The same one who issued the no objection. So whether no objection was taken by VCP Bairabi from landowners concerned before issuing NOC for developing of existing road needs to be clarified. So the landowners have not given their no objection, which has not been annexed. And moreover, my lord, all these submissions should have been submitted during the time of the writ petition, which was done, and judgment was already passed in 19/3/2020. Now, after the contempt case was filed, my lord, contempt case was filed on 17/5/2022. Thereafter, in the meantime, during the pendency of the contempt case, the instant respondent number 6 filed their WPC 112 of 2024 during the pendency, the same pendency of this contempt.
That is I've said.
Yes, and then again they also filed review petition twice. And then the same review petition was again, the last review petition number 4 of 2025 allowed and revived the WPC 112. Which all of this which should have been raised at the time of WPC 148 of 2019.
Yes, this is what I'm saying. They were not, they did not,
So now the only
they
thing.
did not say anything.
My lord, one thing is, my lord,
And moreover, the representative of the respondent number 6 submitted that they have no objection to the prayers of the
lord, that is-
petitioner,
I'm
my lord. So
admitting
now
that, my
why
lord.
raise at a very belated stage?
My lord.
And this case has already been pending since 2019, my lord. On the
Now the
same-
fact remains whether it was the earlier owner and then it is owned by private persons.
Yes, it was owned by
It
private
is
persons.
owned by private persons
And I have
now.
My lord,
purchased.
my lord, timing I'm agree with that, my lord. But thing is that, my lord, it was, my lord, this NOC was from 2015, my lord. Land was sold 2018, my lord. My lord, if there is, my lord, as per my lord, learned friend, my lord, there is another, the land was belongs to village, past was, it belongs to some other, my lord. He never raised any question, my lord. He
No,
never,
my lord.
my lord,
Why will they raise questions?
No, no, it
The
was-
order is in their favor.
my lord, no, my lord.
With respect to that-
Owner from who is who sold this land to the client of my friend, my lord.
My lord, that was
Earlier,
never,
2005
that was never concealed because in the WPC,
There was no requirement.
yes, moreover, my
They
lord,
purchased from the original owner. They are the now owners.
Yes.
Now, if you now the
No, my point is, my lord, is, my lord, we constructed, we developed the road, my lord, after 2015, from 15, my lord.
but she had shown that even that question was there,
Who-
that whether you had taken no objection from
My
the
lord,
original owners.
My lord, so, my lord, here it is written, my lord, this page number 29, my friend shows, my lord, where no objection was taken from the taken by the VC from the landowner concerned before issuing NOC for developing needs to be classified. This was, my lord, not there, my lord. This, my lord, this is the report of the subject collector, my lord, commissioner, my lord. So this was the report. So it is
No,
there.
see, there are so many papers. I have to again go through everything. Otherwise, you are some mixing up.
no,
So what I am on is, you please listen, or I will not take up this case again.
Yes, ma'am.
What is here is the direct direction from the High Court that do this, do that. Now, whether if you want that land, then you have to acquire it, and if you don't, give them the compensation for the damage done. That is a simple direction to you.
My lord,
Now you are going to that, this earlier the land was not theirs, we had the no objection certificate, the road was already there, we had taken it for development. What are all this? You should have pointed out before the bridge court.
My lord, it goes direction only to verify, my lord.
Now you do one thing,
If it is so, my lord, as per it court direction is not only to verify. As per
not
the-
only to verify, after verification you do this.
Yes, my lord. Yes, my lord. I'm coming on that, my lord. After verification, my lord, it was found that it need to classify from the owner of the particular person, my lord. Whether his VCP, village council, my lord, issued the NOC, my lord, after taking consent of the concerned owner, my lord. That is there, my lord.
Those things I'll not go into, because those things you should have pointed out
it is the
in the
part-
writ proceeding. I'll not take up this case. Listed before other bench. You cannot hear me. There is no deliberation at all. Leave this matter before any other bench, not without me. This is not the way one submits. I was there on that side for 22 long years. I know how to submit.
My humble submission, my lord.
No. Your submissions were never humble.
This is, my lord, this is as per this or
No.
court was, my lord, as per the order of the
No. I'm not taking over. I passed the order. I'm taking over today. List this matter before any other bench without me. Any other matter? Same things you're repeating. I'm asking you one simple question. Repeating, you don't listen to me. You keep on saying whatever you want.
My lord, we are given liberty.
This is a contempt. I'm a contempt court now. I'm taking over the contempt matter.
I understand.
Whether you have followed their order or not.
I understand, my lord. So we challenge the petition
No,
report.
it's okay. I passed the order. Okay. You tried before any other bench. Okay. Yes.
Oh,